Students for Fair Admissions vs. Harvard College. Decided June 29, 2023. Syllabus. Harvard College and the University of North Carolina, UNC, are two of the oldest institutions of higher learning in the United States. Every year, tens of thousands of students apply to each school, many fewer are admitted. Both Harvard and UNC employ a highly selective admissions process to make their decisions. Admission to each school can depend on a student's grades, recommendation letters, or extracurricular involvement. It can also depend on their race. The question presented is whether the admissions systems used by Harvard College and UNC are lawful under the Equal Protection Clause of the 14th Amendment. At Harvard, each application for admission is initially screened by a first reader, who assigns a numerical score in each of 6 categories: academic, extracurricular, athletic, school support, personal, and overall. For the overall category, a composite of the 5 other ratings, a first reader can and does consider the applicant's race. Harvard's admissions subcommittees then review all applications from a particular geographic area. These regional subcommittees make recommendations to the full admissions committee, and they take an applicant's race into account. When the 40-member full admissions committee begins its deliberations, it discusses the relative breakdown of applicants by race. The goal of the process, according to Harvard's Director of Admissions, is ensuring there is no dramatic drop-off in minority admissions from the prior class. An applicant receiving a majority of the full committee's votes is tentatively accepted for admission. At the end of this process, the racial composition of the tentative applicant pool is disclosed to the committee. The last stage of Harvard's admissions process, called the LOP, winnows the list of tentatively admitted students to arrive at the final class. Applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. In the Harvard admissions process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. UNC has a similar admissions process. Every application is reviewed first by an admissions office reader, who assigns a numerical rating to each of several categories. Readers are required to consider the applicant's race as a factor in their review. Readers then make a written recommendation on each assigned application, and they may provide an applicant a substantial plus depending on the applicant's race. At this stage, most recommendations are provisionally final. A committee of experienced staff members then conducts a school group review of every initial decision made by a reader and either approves or rejects the recommendation. In making those decisions, the committee may consider the applicant's race. Petitioner, Students for Fair Admissions, SFFA, is a non-profit organization whose stated purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under the law. SFFA filed separate lawsuits against Harvard and UNC, arguing that their race-based admissions programs violate, respectively, Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment. After separate bench trials, both admissions programs were found permissible under the Equal Protection Clause and this court's precedents. In the Harvard case, the First Circuit affirmed, and this court granted certiorari. In the UNC case, this court granted certiorari before judgment. Held, Harvard's and UNC's admissions programs violate the Equal Protection Clause of the 14th Amendment. Because SFFA complies with the standing requirements for organizational plaintiffs articulated by this court in Hunt v. Washington State Apple Advertising Common, SFFA's obligations under Article 3 are satisfied, and this court has jurisdiction to consider the merits of SFFA's claims. The court rejects UNC's argument that SFFA lacks standing because it is not a genuine membership organization. An organizational plaintiff can satisfy Article 3 jurisdiction in 2 ways, one of which is to assert standing solely as the representative of its members, Worth v. Selden, an approach known as representational or organizational standing. To invoke it, an organization must satisfy the 3-part test in Hunt. Respondents do not suggest that SFFA fails Hunt's test for organizational standing. They argue instead that SFFA cannot invoke organizational standing at all because SFFA was not a genuine membership organization at the time it filed suit. Respondents maintain that, under Hunt, a group qualifies as a genuine membership organization only if it is controlled and funded by its members. In Hunt, this court determined that a state agency with no traditional members could still qualify as a genuine membership organization in substance because the agency represented the interests of individuals and otherwise satisfied Hunt's three-part test for organizational standing. Hunt's indicia of membership analysis, however, has no applicability here. As the courts below found, SFFA is indisputably a voluntary membership organization with identifiable members who support its mission and whom SFFA represents in good faith. SFFA is thus entitled to rely on the organizational standing doctrine as articulated in Hunt. Proposed by Congress and ratified by the states in the wake of the Civil War, the 14th Amendment provides that no state shall deny to any person the equal protection of the laws. Proponents of the Equal Protection Clause described its foundational principle as not permitting any distinctions of law based on race or color. Any law which operates upon one man, they maintained, should operate equally upon all. Accordingly, as this court's early decisions interpreting the Equal Protection Clause explained, the 14th Amendment guaranteed that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. Despite the early recognition of the broad sweep of the Equal Protection Clause, the court, alongside the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation a regrettable norm. This court played its own role in that ignoble history, allowing in Plessy v. Ferguson the separate but equal regime that would come to deface much of America. After Plessy, American courts labored with the doctrine of separate but equal for over half a century. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing that it required states to provide black students educational opportunities equal to, even if formally separate from, those enjoyed by white students. Missouri ex rel. But the inherent folly of that approach, of trying to derive equality from inequality, soon became apparent. As the court subsequently recognized, even racial distinctions that were argued to have no palpable effect worked to subordinate the afflicted students. By 1950, the inevitable truth of the 14th Amendment had thus begun to re-emerge: separate cannot be equal. The culmination of this approach came finally in Brown v. Board of Education. There, the court overturned the separate but equal regime established in Plessy and began on the path of invalidating all de jure racial discrimination by the states and federal government. The conclusion reached by the Brown Court was unmistakably clear: the right to a public education must be made available to all on equal terms. The court reiterated that rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non-discriminatory basis. In the years that followed, Brown's fundamental principle that racial discrimination in public education is unconstitutional reached other areas of life, for example, state and local laws requiring segregation in busing, racial segregation in the enjoyment of public beaches and bathhouses, and anti-miscegenation laws. These decisions, and others like them, reflect the core purpose of the Equal Protection Clause, doing away with all governmentally imposed discrimination based on race. Eliminating racial discrimination means eliminating all of it. Accordingly, the court has held that the Equal Protection Clause applies, without regard to any differences of race, of color, or of nationality. It is universal in its application. For, the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. Any exceptions to the Equal Protection Clause's guarantee must survive a daunting two-step examination known as strict scrutiny, which asks first whether the racial classification is used to further compelling governmental interests, and second whether the government's use of race is narrowly tailored, i.e., necessary, to achieve that interest. Acceptance of race-based state action is rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. This court first considered whether a university may make race race-based admissions decisions in Bakke. In a deeply splintered decision that produced 6 different opinions, Justice Powell's opinion for himself alone would eventually come to serve as the touchstone for constitutional analysis of race-conscious admissions policies. After rejecting 3 of the university's 4 justifications as not sufficiently compelling, Justice Powell turned to its last interest asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. Justice Powell found that interest to be a constitutionally permissible goal for an institution of higher education, which was entitled as a matter of academic freedom to make its own judgments as to the selection of its student body. But a university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect, Justice Powell explained, and antipathy toward them was deeply rooted in our nation's constitutional and demographic history. Accordingly, a university could not employ a 2-track quota system with a specific number of seats reserved for individuals from a preferred ethnic group. Neither still could a university use race to foreclose an individual from all consideration. Race could only operate as plus in a particular applicant's file, and even then it had to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant. For years following Bakke, lower courts struggled to determine whether Justice Powell's decision was binding precedent. Then, in Grutter v. Bollinger, the court for the first time endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. The Grutter majority's analysis tracked Justice Powell's in many respects, including its insistence on limits on how universities may consider race in their admissions programs. Those limits, Grutter explained, were intended to guard against 2 dangers that all race-based government action portends. The first is the risk that the use of race will devolve into illegitimate stereotyping. Admissions programs could thus not operate on the belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. The second risk is that race would be used not as a plus, but as a negative, to discriminate against those racial groups that were not the beneficiaries of the race-based preference. A university's use of race, accordingly, could not occur in a manner that unduly harmed non-minority applicants. To manage these concerns, Grutter imposed one final limit on race-based admissions programs. At some point, the court held, they must end. Recognizing that, enshrining a permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection, the court expressed its expectation that, in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years have passed since Grutter, with no end to race-based college admissions in sight. But the court has permitted race-based college admissions only within the confines of narrow restrictions. Such admissions programs must comply with strict scrutiny, may never use race as a stereotype or negative, and must, at some point, end. Respondents' admissions systems fail each of these criteria and must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. Respondents fail to operate their race-based admissions programs in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. First, the interests that respondents view as compelling cannot be subjected to meaningful judicial review. Those interests include training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens. While these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. It is unclear how courts are supposed to measure any of these goals, or if they could, to know when they have been reached so that racial preferences can end. The elusiveness of respondents' asserted goals is further illustrated by comparing them to recognized compelling interests. For example, courts can discern whether the temporary racial segregation of inmates will prevent harm to those in the prison, but the question whether a particular mix of minority students produces engaged and productive citizens, or effectively trains future leaders, is standardless. Second, respondents' admissions programs fail to articulate a meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, respondents measure the racial composition of their classes using racial categories that are plainly overbroad, expressing, for example, no concern whether South Asian or East Asian students are adequately represented as Asian, arbitrary or undefined, the use of the category Hispanic, or underinclusive, no category at all for Middle Eastern students. The unclear connection between the goals that respondents seek and the means they employ preclude courts from meaningfully scrutinizing respondents' admissions programs. The university's main response to these criticisms is, "Trust us." They assert that universities are owed deference when using race to benefit some applicants but not others. While this court has recognized a tradition of giving a degree of deference to a university's academic decisions, it has made clear that deference must exist, within constitutionally prescribed limits. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is measurable and concrete enough to permit judicial review, as the Equal Protection Clause requires. Respondents' race-based admissions systems also fail to comply with the Equal Protection Clause's twin commands that race may never be used as a negative, and that it may not operate as a stereotype. The First Circuit found that Harvard's consideration of race has resulted in fewer admissions of Asian American students. Respondents' assertion that race is never a negative factor in their admissions programs cannot withstand scrutiny. College admissions are zero, some, and a benefit provided to some applicants but not to others necessarily advantages the former at the expense of the latter. Respondents' admissions programs are infirm for a second reason as well: they require stereotyping, the very thing Grutter forswore. When a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. Such stereotyping is contrary to the core purpose of the Equal Protection Clause. Respondents' admissions programs also lack a logical end point, as Grutter required. Respondents suggest that the end of race-based admissions programs will occur once meaningful representation and diversity are achieved on college campuses. Such measures of success amount to little more than comparing the racial breakdown of the incoming class and comparing it to some other metric, such as the racial makeup of the previous incoming class or the population in general, to see whether some proportional goal has been reached. The problem with this approach is well established: outright racial balancing is patently unconstitutional. Respondents' second proffered end point, when students receive the educational benefits of diversity, fares no better. As explained, it is unclear how a court is supposed to determine if or when such goals would be adequately met. Third, respondents suggest the 25-year expectation in Grutter means that race-based preferences must be allowed to continue until at least 2028. The court's statement in Grutter, however, reflected only that court's expectation that race-based preferences would, by 2028, be unnecessary in the context of racial diversity on college campuses. Finally, respondents argue that the frequent reviews they conduct to determine whether racial preferences are still necessary obviates the need for an end point. But Grutter never suggested that periodic review can make unconstitutional conduct constitutional. Because Harvard's and UNC's admissions programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints, those admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. At the same time, nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. Many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. This nation's constitutional history does not tolerate that choice. Opinion of the Court, delivered by Chief Justice Roberts. In these cases we consider whether the admissions systems used by Harvard College and the University of North Carolina, two of the oldest institutions of higher learning in the United States, are lawful under the Equal Protection Clause of the 14th Amendment. Founded in 1636, Harvard College has one of the most selective application processes in the country. Over 60,000 people applied to the school last year, fewer than 2,000 were admitted. Gaining admission to Harvard is thus no easy feat. It can depend on having excellent grades, glowing recommendation letters, or overcoming significant adversity. It can also depend on your race. The admissions process at Harvard works as follows. Every application is initially screened by a first reader, who assigns scores in 6 categories: academic, extracurricular, athletic, school support, personal, and overall. A rating of 1 is the best, a rating of 6 the worst. In the academic category, for example, a 1 signifies near perfect standardized test scores and grades. In the extracurricular category, it indicates truly unusual achievement, and in the personal category, it denotes outstanding attributes like maturity, integrity, leadership, kindness, and courage. A score of 1 on the overall rating, a composite of the 5 other ratings, signifies an exceptional candidate with greater than 90% chance of admission. In assigning the overall rating, the first readers can and do take an applicant's race into account. Once the first read process is complete, Harvard convenes admissions subcommittees. Each subcommittee meets for 3 to 5 days and evaluates all applicants from a particular geographic area. The subcommittees are responsible for making recommendations to the full admissions committee. The subcommittees can and do take an applicant's race into account when making their recommendations. The next step of the Harvard process is the full committee meeting. The committee has 40 members, and its discussion centers around the applicants who have been recommended by the regional subcommittees. At the beginning of the meeting, the committee discusses the relative breakdown of applicants by race. The goal, according to Harvard's Director of Admissions, is to make sure that Harvard does not have a dramatic drop-off in minority admissions from the prior class. Each applicant considered by the full committee is discussed one by one, and every member of the committee must vote on admission. Only when an applicant secures a majority of the full committee's votes is he or she tentatively accepted for admission. At the end of the full committee meeting, the racial composition of the pool of tentatively admitted students is disclosed to the committee. The final stage of Harvard's process is called the LOP, during which the list of tentatively admitted students is winnowed further to arrive at the final class. Any applicants that Harvard considers cutting at this stage are placed on a LOP list, which contains only 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. The full committee decides as a group which students to LOP. In doing so, the committee can and does take race into account. Once the LOP process is complete, Harvard's admitted class is set. In the Harvard admissions process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. Founded shortly after the Constitution was ratified, the University of North Carolina, UNC, prides itself on being the nation's first public university. Like Harvard, UNC's admissions process is highly selective. In a typical year, the school receives approximately 43,500 applications for its freshman class of 4,200. Every application the university receives is initially reviewed by one of approximately 40 admissions office readers, each of whom reviews roughly 5 applications per hour. Readers are required to consider race and ethnicity as one factor in their review. Other factors include academic performance and rigor, standardized testing results, extracurricular involvement, essay quality, personal factors, and student background. Readers are responsible for providing numerical ratings for the academic, extracurricular, personal, and essay categories. During the years at issue in this litigation, underrepresented minority students were more likely to score highly on their personal ratings than their white and Asian American peers, but were more likely to be rated lower by UNC readers on their academic program, academic performance, extracurricular activities, and essays. After assessing an applicant's materials along these lines, the reader formulates an opinion about whether the student should be offered admission, and then writes a comment defending his or her recommended decision. In making that decision, readers may offer students a plus based on their race, which may be significant in an individual case. The admissions decisions made by the first readers are, in most cases, provisionally final. Following the first read process, applications then go to a process called school group review, where a committee composed of experienced staff members reviews every initial decision. The review committee receives a report on each student which contains, among other things, their class rank, GPA, and test scores the ratings assigned to them by their initial readers and their status as residents, legacies, or special recruits. The review committee either approves or rejects each admission recommendation made by the first reader, after which the admissions decisions are finalized. In making those decisions, the review committee may also consider the applicant's race. Petitioner, Students for Fair Admissions, SFFA, is a non-profit organization founded in 2014 whose purpose is to defend human and civil rights secured by law, including the right of individuals to equal protection under the law. In November 2014, SFFA filed separate lawsuits against Harvard College and the University of North Carolina, arguing that their race-based admissions programs violated, respectively, Title VI of the Civil Rights Act of 1964 and the Equal Protection Clause of the 14th Amendment. The district courts in both cases held bench trials to evaluate SFFA's claims. Trial in the Harvard case lasted 15 days and included testimony from 30 witnesses, after which the court concluded that Harvard's admissions program comported with our precedents on the use of race in college admissions. The First Circuit affirmed that determination. Similarly, in the UNC case, the district court concluded after an 8-day trial that UNC's admissions program was permissible under the Equal Protection Clause. We granted certiorari in the Harvard case and certiorari before judgment in the UNC case. Before turning to the merits, we must assure ourselves of our jurisdiction. UNC argues that SFFA lacks standing to bring its claims because it is not a genuine membership organization. Every court to have considered this argument has rejected it, and so do we. Article 3 of the Constitution limits the judicial power of the United States to cases or controversies, ensuring that federal courts act only as a necessity in the determination of real, earnest, and vital disputes. To state a case or controversy under Article 3, a plaintiff must establish standing. That, in turn, requires a plaintiff to demonstrate that it has, 1. Suffered an injury in fact, 2. That is fairly traceable to the challenged conduct of the defendant, and, 3. That is likely to be redressed by a favorable judicial decision. In cases like these, where the plaintiff is an organization, the standing requirements of Article 3 can be satisfied in two ways. Either the organization can claim that it suffered an injury in its own right or, alternatively, it can assert standing solely as the representative of its members. The latter approach is known as representational or organizational standing. To invoke it, an organization must demonstrate that, a. its members would otherwise have standing to sue in their own right, b. the interests it seeks to protect are germane to the organization's purpose, and c. neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. Respondents do not contest that SFFA satisfies the three-part test for organizational standing articulated in Hunt, and like the courts below, we find no basis in the record to conclude otherwise. Respondents instead argue that SFFA was not a genuine membership organization when it filed suit, and thus that it could not invoke the doctrine of organizational standing in the first place. And because SFFA's members did neither at the time this litigation commenced, respondents' argument goes, SFFA could not represent its members for purposes of Article 3 standing. The Commission brought suit challenging a North Carolina statute that imposed a labeling requirement on containers of apples sold in that state. The Commission argued that it had standing to challenge the requirement on behalf of Washington's apple industry. We recognized, however, that as a state agency, the Commission was not a traditional voluntary membership organization, for it had no members at all. As a result, we could not easily apply the three-part test for organizational standing, which asks whether an organization's members have standing. We nevertheless concluded that the Commission had standing because the apple growers and dealers it represented were effectively members of the Commission. The growers and dealers alone elected the members of the Commission, alone served on the Commission, and alone financed its activities. They possessed, in other words, all of the indicia of membership. The Commission was therefore a genuine membership organization in substance, if not in form. And it was, clearly, entitled to rely on the doctrine of organizational standing under the three-part test recounted above. The indicia of membership analysis employed in Hunt has no applicability in these cases. Here, SFFA is indisputably a voluntary membership organization with identifiable members. It is not, as in Hunt, a state agency that concededly has no members. As the First Circuit in the Harvard litigation observed, at the time SFFA filed suit, it was a validly incorporated 501(c)(3) nonprofit with 47 members who joined voluntarily to support its mission. Meanwhile, in the UNC litigation, SFFA represented 4 members in particular, high school graduates who were denied admission to UNC. Those members filed declarations with the district court stating that they have voluntarily joined SFFA, they support its mission, they receive updates about the status of the case from SFFA's president, and they have had the opportunity to have input and direction on SFFA's case. Where, as here, an organization has identified members and represents them in good faith, our cases do not require further scrutiny into how the organization operates. Because SFFA complies with the standing requirements demanded of organizational plaintiffs in Hunt, its obligations under Article 3 are satisfied. In the wake of the Civil War, Congress proposed and the states ratified the 14th Amendment, providing that no state shall deny to any person the equal protection of the laws. To its proponents, the Equal Protection Clause represented a foundational principle, the absolute equality of all citizens of the United States politically and civilly before their own laws. The Constitution, they were determined, should not permit any distinctions of law based on race or color, because any law which operates upon one man should operate equally upon all. As soon-to-be President James Garfield observed, the 14th Amendment would hold over every American citizen, without regard to color, the protecting shield of law. And in doing so, said Senator Jacob Howard of Michigan, the amendment would give, to the humblest, the poorest, the most despised of the race the same rights and the same protection before the law as it gives to the most powerful, the most wealthy, or the most haughty. For, without this principle of equal justice, Howard continued, there is no Republican government and none that is really worth maintaining. At first, this court embraced the transcendent aims of the Equal Protection Clause. What is this, we said of the clause in 1880, but declaring that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. The broad and benign provisions of the 14th Amendment apply to all persons, we unanimously declared 6 years later. It is hostility to race and nationality, which in the eye of the law is not justified. Despite our early recognition of the broad sweep of the Equal Protection Clause, this court, alongside the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation a regrettable norm. This court played its own role in that ignoble history, allowing in Plessy v. Ferguson the separate but equal regime that would come to deface much of America. The aspirations of the framers of the Equal Protection Clause, virtually strangled in their infancy, would remain for too long only that, aspirations. After Plessy, American courts labored with the doctrine of separate but equal for over half a century. Some cases in this period attempted to curtail the perniciousness of the doctrine by emphasizing that it required states to provide black students educational opportunities equal to, even if formally separate from, those enjoyed by white students. Missouri ex rel. Gaines v. Canada, the admissibility of laws separating the races in the enjoyment of privileges afforded by the state rests wholly upon the equality of the privileges which the laws give to the separated groups. But the inherent folly of that approach, of trying to derive equality from inequality, soon became apparent. As the court subsequently recognized, even racial distinctions that were argued to have no palpable effect worked to subordinate the afflicted students. McLaurin v. Oklahoma State Regents for Higher Ed, it is said that the separations imposed by the state in this case are in form merely nominal. But they signify that the state sets petitioner apart from the other students. By 1950, the inevitable truth of the 14th Amendment had thus begun to re-emerge: separate cannot be equal. The culmination of this approach came finally in Brown v. Board of Education. In that seminal decision, we overturned Plessy for good and set firmly on the path of invalidating all de jure racial discrimination by the states and federal government. Brown concerned the permissibility of racial segregation in public schools. The school district maintained that such segregation was lawful because the schools provided to black students and white students were of roughly the same quality. But we held such segregation impermissible, even though the physical facilities and other tangible factors may be equal. The mere act of separating children because of their race, we explained, itself generated a feeling of inferiority. The conclusion reached by the Brown Court was thus unmistakably clear: the right to a public education must be made available to all on equal terms. As the plaintiffs had argued, no state has any authority under the Equal Protection Clause of the 14th Amendment to use race as a factor in affording educational opportunities among its citizens. That the Constitution is colorblind is our dedicated belief. The court reiterated that rule just 1 year later, holding that full compliance with Brown required schools to admit students on a racially non-discriminatory basis. The time for making distinctions based on race had passed. Brown, the court observed, declared the fundamental principle that racial discrimination in public education is unconstitutional. So too in other areas of life. Immediately after Brown, we began routinely affirming lower court decisions that invalidated all manner of race-based state action. In Gale v. Browder, for example, we summarily affirmed a decision invalidating state and local laws that required segregation in busing. As the lower court explained, the Equal Protection Clause requires equality of treatment before the law for all persons without regard to race or color. And in Mayor and City Council of Baltimore v. Dawson, we summarily affirmed a decision striking down racial segregation at public beaches and bathhouses maintained by the state of Maryland and the city of Baltimore. It is obvious that racial segregation in recreational activities can no longer be sustained, the lower court observed. The ideal of equality before the law which characterizes our institutions demanded as much. In the decades that followed, this court continued to vindicate the Constitution's pledge of racial equality. Laws dividing parks and golf courses, neighborhoods and businesses, buses and trains, schools and juries were undone, all by a transformative promise stemming from our American ideal of fairness. The Constitution forbids discrimination by the general government, or by the states, against any citizen because of his race. As we recounted in striking down the state of Virginia's ban on interracial marriage 13 years after Brown, the 14th Amendment proscribes all invidious racial discriminations. Our cases had thus consistently denied the constitutionality of measures which restrict the rights of citizens on account of race. These decisions reflect the core purpose of the Equal Protection Clause, doing away with all governmentally imposed discrimination based on race. We have recognized that repeatedly. The clear and central purpose of the 14th Amendment was to eliminate all official state sources of invidious racial discrimination in the states. The historical fact is that the central purpose of the 14th Amendment was to eliminate racial discrimination. Eliminating racial discrimination means eliminating all of it. And the Equal Protection Clause, we have accordingly held, applies, without regard to any differences of race, of color, or of nationality. It is universal in its application. For, the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. Any exception to the Constitution's demand for equal protection must survive a daunting two-step examination known in our cases as strict scrutiny. Under that standard we ask, first, whether the racial classification is used to further compelling governmental interests. Second, if so, we ask whether the government's use of race is narrowly tailored, meaning necessary, to achieve that interest. Outside the circumstances of these cases, our precedents have identified only two compelling interests that permit resort to race-based government action. One is remediating specific, identified instances of past discrimination that violated the Constitution or a statute. The second is avoiding imminent and serious risks to human safety in prisons, such as a race riot. Our acceptance of race-based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. That principle cannot be overridden except in the most extraordinary case. These cases involve whether a university may make admissions decisions that turn on an applicant's race. Our court first considered that issue in Regents of University of California v. Bakke, which involved a set-aside admissions program used by the University of California, Davis, Medical School. Each year, the school held 16 of its 100 seats open for members of certain minority groups, who were reviewed on a special admissions track separate from those in the main admissions pool. The plaintiff, Alan Bakke, was denied admission 2 years in a row, despite the admission of minority applicants with lower grade point averages and MCAT scores. Bakke subsequently sued the school, arguing that its set-aside program violated the Equal Protection Clause. In a deeply splintered decision that produced 6 different opinions, none of which commanded a majority of the court, we ultimately ruled in part in favor of the school and in part in favor of Bakke. Justice Powell announced the court's judgment, and his opinion, though written for himself alone, would eventually come to serve as the touchstone for constitutional analysis of race-conscious admissions policies. Justice Powell began by finding 3 of the school's 4 justifications for its policy not sufficiently compelling. The school's first justification of reducing the historic deficit of traditionally disfavored minorities in medical schools, he wrote, was akin to preferring members of any one group for no reason other than race or ethnic origin. Yet that was discrimination for its own sake, which the Constitution forbids. Justice Powell next observed that the goal of remedying the effects of societal discrimination was also insufficient because it was an amorphous concept of injury that may be ageless in its reach into the past. Finally, Justice Powell found there was virtually no evidence in the record indicating that the school's special admissions program would, as the school had argued, increase the number of doctors working in underserved areas. Justice Powell then turned to the school's last interest asserted to be compelling, obtaining the educational benefits that flow from a racially diverse student body. That interest, in his view, was a constitutionally permissible goal for an institution of higher education. And that was so, he opined, because a university was entitled as a matter of academic freedom, to make its own judgments as to the selection of its student body. But a university's freedom was not unlimited. Racial and ethnic distinctions of any sort are inherently suspect, Justice Powell explained, and antipathy toward them was deeply rooted in our nation's constitutional and demographic history. A university could not employ a quota system, for example, reserving a specified number of seats in each class for individuals from the preferred ethnic groups. Nor could it impose a multi-track program with a prescribed number of seats set aside for each identifiable category of applicants. And neither still could it use race to foreclose an individual from all consideration simply because he was not the right color. The role of race had to be cabined. It could operate only as a plus in a particular applicant's file. And even then, race was to be weighed in a manner flexible enough to consider all pertinent elements of diversity in light of the particular qualifications of each applicant. Justice Powell derived this approach from what he called the illuminating example of the admissions system then used by Harvard College. Under that system, as described by Harvard in a brief it had filed with the court, the race of an applicant may tip the balance in his favor just as geographic origin or a life experience may tip the balance in other candidates' cases. A farm boy from Idaho can bring something to Harvard College that a Bostonian cannot offer. Similarly, a black student can usually bring something that a white person cannot offer. The result, Harvard proclaimed, was that race has been, and should be, a factor in some admission decisions. No other member of the court joined Justice Powell's opinion. For justices instead would have held that the government may use race for the purpose of remedying the effects of past societal discrimination. 4 other justices, meanwhile, would have struck down the Davis program as violative of Title VI. In their view, it seemed clear that the proponents of Title VI assumed that the Constitution itself required a colorblind standard on the part of government. The Davis program therefore flatly contravened a core principle embedded in the constitutional and moral understanding of the times, the prohibition against racial discrimination. In the years that followed our fractured decision in Bakke, lower courts struggled to discern whether Justice Powell's opinion constituted binding precedent. We accordingly took up the matter again in 2003, in the case Grutter v. Bollinger, which concerned the admissions system used by the University of Michigan Law School. There, in another sharply divided decision, the court for the first time endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use of race in university admissions. The court's analysis tracked Justice Powell's in many respects. As for compelling interest, the court held that the law school's educational judgment that such diversity is essential to its educational mission is one to which we defer. In achieving that goal, however, the court made clear, just as Justice Powell had, that the law school was limited in the means that it could pursue. The school could not establish quotas for members of certain racial groups or put members of those groups on separate admissions tracks. Neither could it insulate applicants who belonged to certain racial or ethnic groups from the competition for admission. Nor still could it desire some specified percentage of a particular group merely because of its race or ethnic origin. These limits, Grutter explained, were intended to guard against two dangers that all race-based government action portends. The first is the risk that the use of race will devolve into illegitimate stereotyping. Universities were thus not permitted to operate their admissions programs on the belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. The second risk is that race would be used not as a plus, but as a negative, to discriminate against those racial groups that were not the beneficiaries of the race-based preference. A university's use of race, accordingly, could not occur in a manner that unduly harmed non-minority applicants. But even with these constraints in place, Grutter expressed marked discomfort with the use of race in college admissions. The court stressed the fundamental principle that there are serious problems of justice connected with the idea of racial preference itself. It observed that all racial classifications, however compelling their goals, were dangerous. And it cautioned that all race-based governmental action should remain subject to continuing oversight to assure that it will work the least harm possible to other innocent persons competing for the benefit. To manage these concerns, Grutter imposed one final limit on race-based admissions programs. At some point, the court held, they must end. This requirement was critical, and Grutter emphasized it repeatedly. All race-conscious admissions programs must have a termination point, they must have reasonable durational limits, they must be limited in time, they must have sunset provisions, they must have a logical end point, their deviation from the norm of equal treatment must be a temporary matter. The importance of an end point was not just a matter of repetition. It was the reason the court was willing to dispense temporarily with the Constitution's unambiguous guarantee of equal protection. The court recognized as much, enshrining a permanent justification for racial preferences, the court explained, would offend this fundamental equal protection principle, see also ID. Quoting Nathanson and Bartnick, the constitutionality of preferential treatment for minority applicants to professional schools, 58 Chi Bar Rec. 282, 293, for the proposition that, it would be a sad day indeed, were America to become a quota-ridden society, with each identifiable minority assigned proportional representation in every desirable walk of life. Grutter thus concluded with the following caution, it has been 25 years since Justice Powell first approved the use of race to further an interest in student body diversity in the context of public higher education that we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years later, no end is in sight. Harvard's view about when race-based admissions will end doesn't have a date on it. Neither does UNC's. Yet both insist that the use of race in their admissions programs must continue. But we have permitted race-based admissions only within the confines of narrow restrictions. University programs must comply with strict scrutiny, they may never use race as a stereotype or negative, and, at some point, they must end. Respondents' admissions systems, however well-intentioned and implemented in good faith, fail each of these criteria. They must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. Because racial discrimination is invidious in all contexts, we have required that universities operate their race-based admissions programs in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. Classifying and assigning students based on their race requires more than an amorphous end to justify it. Respondents have fallen short of satisfying that burden. First, the interests they view as compelling cannot be subjected to meaningful judicial review. Harvard identifies the following educational benefits that it is pursuing: 1. Training future leaders in the public and private sectors, 2. Preparing graduates to adapt to an increasingly pluralistic society, 3. Better educating its students through diversity, and 4. Producing new knowledge stemming from diverse outlooks. UNC points to similar benefits, namely, 1. Promoting the robust exchange of ideas, 2. Broadening and refining understanding, 3. Fostering innovation and problem-solving, 4. Preparing engaged and productive citizens and leaders, and 5. Enhancing appreciation, respect, and empathy, cross-racial understanding, and breaking down stereotypes. Although these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. At the outset, it is unclear how courts are supposed to measure any of these goals. How is a court to know whether leaders have been adequately trained, whether the exchange of ideas is robust, or whether new knowledge is being developed? Even if these goals could somehow be measured, moreover, how is a court to know when they have been reached, and when the perilous remedy of racial preferences may cease? There is no particular point at which there exists sufficient innovation and problem-solving, or students who are appropriately engaged and productive. Finally, the question in this context is not one of no diversity or of some, it is a question of degree. How many fewer leaders Harvard would create without racial preferences, or how much poorer the education at Harvard would be, are inquiries no court could resolve. Comparing respondents' asserted goals to interests we have recognized as compelling further illustrates their elusive nature. In the context of racial violence in a prison, for example, courts can ask whether temporary racial segregation of inmates will prevent harm to those in the prison. When it comes to workplace discrimination, courts can ask whether a race-based benefit makes members of the discriminated class whole for the injuries they suffered. And in school segregation cases, courts can determine whether any race-based remedial action produces a distribution of students comparable to what it would have been in the absence of such constitutional violations. Nothing like that is possible when it comes to evaluating the interests respondents assert here. Unlike discerning whether a prisoner will be injured or whether an employee should receive back pay, the question whether a particular mix of minority students produces engaged and productive citizens sufficiently enhances appreciation, respect, and empathy, or effectively trains future leaders, is standardless. The interests that respondents seek, though plainly worthy, are inescapably imponderable. Second, respondents' admissions programs fail to articulate a meaningful connection between the means they employ and the goals they pursue. To achieve the educational benefits of diversity, UNC works to avoid the underrepresentation of minority groups SUP, 3D, and, while Harvard likewise guards against inadvertent drop-offs in representation of certain minority groups from year to year, it is far from evident, though, how assigning students to these racial categories and making admissions decisions based on them furthers the educational benefits that the universities claim to pursue. For starters, the categories are themselves imprecise in many ways. Some of them are plainly overbroad. By grouping together all Asian students, for instance, respondents are apparently uninterested in whether South Asian or East Asian students are adequately represented, so long as there is enough of one to compensate for a lack of the other. Meanwhile, other racial categories, such as Hispanic, are arbitrary or undefined. Lopez, Krogstad, and Passel, Pew Research Center, who is Hispanic? Referencing the long history of changing labels and shifting categories reflecting evolving cultural norms about what it means to be Hispanic or Latino in the U.S. today. And still other categories are underinclusive. When asked at oral argument how are applicants from Middle Eastern countries classified, such as Jordan, Iraq, Iran, and Egypt, UNC's counsel responded, "I do not know the answer to that question." Tr. of Oral Arg in number 21-707, cf. Post, detailing the incoherent and irrational stereotypes that these racial categories further. Indeed, the use of these opaque racial categories undermines, instead of promotes, respondents' goals. By focusing on underrepresentation, respondents would apparently prefer a class with 15% of students from Mexico over a class with 10% of students from several Latin American countries, simply because the former contains more Hispanic students than the latter. Yet, it is hard to understand how a plan that could allow these results can be viewed as being concerned with achieving enrollment that is broadly diverse. And given the mismatch between the means respondents employ and the goals they seek, it is especially hard to understand how courts are supposed to scrutinize the admissions programs that respondents use. The university's main response to these criticisms is, essentially, trust us. None of the questions recited above need answering, they say, because universities are owed deference when using race to benefit some applicants but not others. And that deference does not imply abandonment or abdication of judicial review. Universities may define their missions as they see fit. The Constitution defines ours. Courts may not license separating students on the basis of race without an exceedingly persuasive justification that is measurable and concrete enough to permit judicial review. As this court has repeatedly reaffirmed, racial classifications are simply too pernicious to permit any but the most exact connection between justification and classification. The programs at issue here do not satisfy that standard. The race-based admissions systems that respondents employ also fail to comply with the twin commands of the Equal Protection Clause that race may never be used as a negative, and that it may not operate as a stereotype. First, our cases have stressed that an individual's race may never be used against him in the admissions process. Here, however, the First Circuit found that Harvard's consideration of race has led to an 11.1% decrease in the number of Asian Americans admitted to Harvard. And the district court observed that Harvard's policy of considering applicants' race overall results in fewer Asian American and white students being admitted. Respondents nonetheless contend that an individual's race is never a negative factor in their admissions programs, but that assertion cannot withstand scrutiny. Harvard, for example, draws an analogy between race and other factors it considers in admission. While admissions officers may give a preference to applicants likely to excel in the Harvard-Radcliffe Orchestra, Harvard explains, that does not mean it is a negative not to excel at a musical instrument. This understanding of the admissions process is hard to take seriously. College admissions are zero-sum. A benefit provided to some applicants but not to others necessarily advantages the former group at the expense of the latter. Respondents also suggest that race is not a negative factor because it does not impact many admissions decisions. And they acknowledge that race is determinative for at least some, if not many, of the students they admit. How else but negative can race be described if, in its absence, members of some racial groups would be admitted in greater numbers than they otherwise would have been? The equal protection of the laws is not achieved through indiscriminate imposition of inequalities. Respondents' admissions programs are infirm for a second reason as well. We have long held that universities may not operate their admissions programs on the belief that minority students always, or even consistently, express some characteristic minority viewpoint on any issue. That requirement is found throughout our Equal Protection Clause jurisprudence more generally. Schutt v. BMN, in cautioning against impermissible racial stereotypes, this court has rejected the assumption that members of the same racial group, regardless of their age, education, economic status, or the community in which they live, think alike. Yet by accepting race-based admissions programs in which some students may obtain preferences on the basis of race alone, respondents' programs tolerate the very thing that Grutter forswore, stereotyping. The point of respondents' admissions programs is that there is an inherent benefit in race qua race, in race for race's sake. Respondents admit as much. Harvard's admissions process rests on the pernicious stereotype that a black student can usually bring something that a white person cannot offer. Bakke, Opinion of Powell, J. See also tr. of Oral Arg in No. 20 to 1199. UNC is much the same. It argues that race in itself says something about who you are. Tr. of Oral Arg in No. 21 to 707 see also ID. Analogizing being of a certain race to being from a rural area. We have time and again forcefully rejected the notion that government actors may intentionally allocate preference to those, who may have little in common with one another but the color of their skin. The entire point of the Equal Protection Clause is that treating someone differently because of their skin color is not like treating them differently because they are from a city or from a suburb, or because they play the violin poorly or well. One of the principal reasons race is treated as a forbidden classification is that it demeans the dignity and worth of a person to be judged by ancestry instead of by his or her own merit and essential qualities. But when a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike, at the very least alike in the sense of being different from non-minority students. In doing so, the university furthers stereotypes that treat individuals as the product of their race, evaluating their thoughts and efforts, their very worth as citizens, according to a criterion barred to the government by history and the Constitution. Such stereotyping can only cause continued hurt and injury, contrary as it is to the core purpose of the Equal Protection Clause. If all this were not enough, respondents' admissions programs also lack a logical endpoint. Respondents and the government first suggest that respondents' race-based admissions programs will end when, in their absence, there is meaningful representation and meaningful diversity on college campuses. The metric of meaningful representation, respondents assert, does not involve any strict numerical benchmark or precise number or percentage or specified percentage. And, if at some point in the admissions process it appears that a group is notably underrepresented or has suffered a dramatic drop-off relative to the prior year, the admissions committee may decide to give additional attention to applications from students within that group. See also, District Court finding that Harvard uses race to track how each class is shaping up relative to previous years with an eye towards achieving a level of racial diversity. The results of the Harvard admissions process reflect this numerical commitment. For the admitted classes of 2009 to 2018, black students represented a tight band of 10.0% to 11.7% of the admitted pool. The same theme held true for other minority groups. Harvard's focus on numbers is obvious. UNC's admissions program operates similarly. The university frames the challenge it faces as the admission and enrollment of underrepresented minorities. The university has not yet fully achieved its diversity-related educational goals, it explains, in part due to its failure to obtain closer to proportional representation. By promising to terminate their use of race only when some rough percentage of various racial groups is admitted, respondents turn that principle on its head. Their admissions programs effectively assure that race will always be relevant and that the ultimate goal of eliminating race as a criterion will never be achieved. Respondents' second proffered end point fares no better. Respondents assert that universities will no longer need to engage in race-based admissions when, in their absence, students nevertheless receive the educational benefits of diversity. But as we have already explained, it is not clear how a court is supposed to determine when stereotypes have broken down or productive citizens and leaders have been created. Nor is there any way to know whether those goals would adequately be met in the absence of a race-based admissions program. As UNC itself acknowledges, these qualitative standards are difficult to measure. Third, respondents suggest that race-based preferences must be allowed to continue for at least 5 more years, based on the court's statement in Grutter that it expected that 25 years from now, the use of racial preferences will no longer be necessary. The 25-year mark articulated in Grutter, however, reflected only that court's view that race-based preferences would, by 2028, be unnecessary to ensure a requisite level of racial diversity on college campuses. That expectation was oversold. Neither Harvard nor UNC believes that race-based admissions will in fact be unnecessary in 5 years, and both universities thus expect to continue using race as a criterion well beyond the time limit that Grutter suggested. Indeed, the high school applicants that Harvard and UNC will evaluate this fall using their race-based admissions systems are expected to graduate in 2028, 25 years after Grutter was decided. Finally, respondents argue that their programs need not have an end point at all because they frequently review them to determine whether they remain necessary. But Grutter never suggested that periodic review could make unconstitutional conduct constitutional. To the contrary, the court made clear that race-based admissions programs eventually had to end, despite whatever periodic review universities conducted. Here, however, Harvard concedes that its race-based admissions program has no end point. The university admits that it has not set forth a proposed time period in which it believes it can end all race-conscious admissions practices. Sup. 3d. And UNC suggests that it might soon use race to a greater extent than it currently does. The dissenting opinions resist these conclusions. They would instead uphold respondents' admissions programs based on their view that the 14th Amendment permits state actors to remedy the effects of societal discrimination through explicitly race-based measures. Although both opinions are thorough and thoughtful in many respects, this court has long rejected their core thesis. The dissent's interpretation of the Equal Protection Clause is not new. In Bakke, four justices would have permitted race-based admissions programs to remedy the effects of societal discrimination. But that minority view was just that, a minority view. Justice Powell, who provided the fifth vote and controlling opinion in Bakke, firmly rejected the notion that societal discrimination constituted a compelling interest. Such an interest presents an amorphous concept of injury that may be ageless in its reach into the past. It cannot justify a racial classification that imposes disadvantages upon persons who bear no responsibility for whatever harm the beneficiaries of the race-based admissions program are thought to have suffered. The court soon adopted Justice Powell's analysis as its own. In the years after Bakke, the court repeatedly held that ameliorating societal discrimination does not constitute a compelling interest that justifies race-based state action. An effort to alleviate the effects of societal discrimination is not a compelling interest, we said plainly in Hunt, a 1996 case about the Voting Rights Act. We reached the same conclusion in Croson, a case that concerned a preferential government contracting program. Permitting past societal discrimination to serve as the basis for rigid racial preferences would be to open the door to competing claims for remedial relief for every disadvantaged group. Opening that door would shutter another, the dream of a nation of equal citizens would be lost, we observed, in a mosaic of shifting preferences based on inherently unmeasurable claims of past wrongs. Such a result would be contrary to both the letter and spirit of a constitutional provision whose central command is equality. The dissents here do not acknowledge any of this. They fail to cite Hunt. They fail to cite Croson. They fail to mention that the entirety of their analysis of the Equal Protection Clause, the statistics, the cases, the history, has been considered and rejected before. There is a reason the principal dissent must invoke Justice Marshall's partial dissent in Bakke nearly a dozen times while mentioning Justice Powell's controlling opinion barely once. Justice Jackson's opinion ignores Justice Powell altogether. For what one dissent denigrates as rhetorical flourishes about colorblindness, are in fact the proud pronouncements of cases like Loving and Yickwa, like Shelley and Bolling. They are defining statements of law. We understand the dissents want that law to be different. They are entitled to that desire. But they surely cannot claim the mantle of stare decisis while pursuing it. The dissents are no more faithful to our precedent on race-based admissions. To hear the principal dissent tell it, Grutter blessed such programs indefinitely, until racial inequality will end. But Grutter did no such thing. It emphasized, not once or twice, but at least 6 separate times, that race-based admissions programs must have reasonable durational limits and that their deviation from the norm of equal treatment must be a temporary matter. The court also disclaimed enshrining a permanent justification for racial preferences. Yet the justification for race-based admissions that the dissent latches on to is just that, unceasing. The principal dissent's reliance on Fisher too is similarly mistaken. There, by a 4-3 vote, the court upheld a sui generis race-based admissions program used by the University of Texas, whose goal it was to enroll a critical mass of certain minority students. Fisher, but neither Harvard nor UNC claims to be using the critical mass concept. Indeed, the universities admit they do not even know what it means. See 1 App, in number 21 to 707, no one has directed anybody to achieve a critical mass, and I'm not even sure we would know what it is. Testimony of UNC Administrator, 3 App, in number 20 to 1199, similar testimony from Harvard Administrator. Fisher too also recognized the enduring challenge that race-based admissions systems place on the constitutional promise of equal treatment. The court thus reaffirmed the continuing obligation of universities to satisfy the burden of strict scrutiny. To drive the point home, Fisher too limited itself just as Grutter had, in duration. The court stressed that its decision did not necessarily mean the university may rely on the same policy going forward. See also Fisher I, recognizing that Grutter approved the plan at issue upon concluding that it was limited in time. And the court openly acknowledged that its decision offered limited, prospective guidance. The principal dissent wrenches our case law from its context, going to lengths to ignore the parts of that law it does not like. The serious reservations that Bakke, Grutter, and Fisher had about racial preferences go unrecognized. The unambiguous requirements of the Equal Protection Clause, the most rigid, searching scrutiny it entails, go without note. And the repeated demands that race-based admissions programs must end go overlooked, contorted, worse still, into a demand that such programs never stop. Most troubling of all is what the dissent must make these omissions to defend, a judiciary that picks winners and losers based on the color of their skin. While the dissent would certainly not permit university programs that discriminated against Black and Latino applicants, it is perfectly willing to let the programs here continue. In its view, this court is supposed to tell state actors when they have picked the right races to benefit. Separate but equal is inherently unequal, said Brown. It depends, says the dissent. That is a remarkable view of the judicial role, remarkably wrong. Lost in the false pretense of judicial humility that the dissent espouses is a claim to power so radical, so destructive, that it required a second founding to undo. Justice Harlan knew better, one of the dissent's decrees. Indeed he did. In view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. For the reasons provided above, the Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today. At the same time, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But, despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. A dissenting opinion is generally not the best source of legal advice on how to comply with the majority opinion. What cannot be done directly cannot be done indirectly. The Constitution deals with substance, not shadows, and the prohibition against racial discrimination is leveled at the thing, not the name. A benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination. Or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have for too long done just the opposite. And in doing so, they have concluded, wrongly, that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned but the color of their skin. Our constitutional history does not tolerate that choice. The judgments of the Court of Appeals for the First Circuit and of the District Court for the Middle District of North Carolina are reversed. It is so ordered. Justice Jackson took no part in the consideration or decision of the case in number 20 to 1199. Concurring opinion of Justice Thomas. In the wake of the Civil War, the country focused its attention on restoring the Union and establishing the legal status of newly freed slaves. The Constitution was amended to abolish slavery and proclaim that all persons born in the United States are citizens, entitled to the privileges or immunities of citizenship and the equal protection of the laws. Because of that second founding, our Constitution is colorblind, and neither knows nor tolerates classes among citizens. This court's commitment to that equality principle has ebbed and flowed over time. After forsaking the principle for decades, offering a judicial imprimatur to segregation and ushering in the Jim Crow era, the court finally corrected course in Brown v. Board of Education, announcing that primary schools must either desegregate with all deliberate speed or else close their doors. It then pulled Bakke and Grutter v. Bollinger, permitting universities to discriminate based on race in their admissions process, though only temporarily, in order to achieve alleged educational benefits of diversity. Yet, the Constitution continues to embody a simple truth: two discriminatory wrongs cannot make a right. I wrote separately in Grutter, explaining that the use of race in higher education admissions decisions, regardless of whether intended to help or to hurt, violates the 14th Amendment. In the decades since, I have repeatedly stated that Grutter was wrongly decided and should be overruled. Today, and despite a lengthy interregnum, the Constitution prevails. Because the court today applies genuine strict scrutiny to the race-conscious admissions policies employed at Harvard and the University of North Carolina, UNC, and finds that they fail that searching review, I join the majority opinion in full. I write separately to offer an originalist defense of the colorblind Constitution to explain further the flaws of the court's Grutter jurisprudence, to clarify that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution, and to emphasize the pernicious effects of all such discrimination. In the 1860s, Congress proposed and the states ratified the 13th and 14th Amendments. And, with the authority conferred by these amendments, Congress passed two landmark civil rights acts. Throughout the debates on each of these measures, their proponents repeatedly affirmed their view of equal citizenship and the racial equality that flows from it. In fact, they held this principle so deeply that their crowning accomplishment, the 14th Amendment, ensures racial equality with no textual reference to race whatsoever. The history of these measures' enactment renders their motivating principle as clear as their text: all citizens of the United States, regardless of skin color, are equal before the law. I do not contend that all of the individuals who put forth and ratified the 14th Amendment universally believed this to be true. Some members of the proposing Congress, for example, opposed the amendment. And the historical record, particularly with respect to the debates on ratification in the states, is sparse. Nonetheless, substantial evidence suggests that the 14th Amendment was passed to establish the broad constitutional principle of full and complete equality of all persons under the law, forbidding all legal distinctions based on race or color. Sup. Brief for United States on Re-argument in Brown v. Board of Education, T. 1953. This was Justice Harlan's view in his lone dissent in Plessy, where he observed that our Constitution is colorblind. It was the view of the court in Brown, which rejected any authority to use race as a factor in affording educational opportunities. And it is the view adopted in the court's opinion today, requiring the absolute equality of all citizens under the law. In its 1864 election platform, the Republican Party pledged to amend the Constitution to accomplish the utter and complete extirpation of slavery from the soil of the Republic. After their landslide victory, Republicans quickly moved to make good on that promise. Congress proposed what would become the 13th Amendment to the states in January 1865, and it was ratified as part of the Constitution later that year. The new amendment stated that neither slavery nor involuntary servitude shall exist in the United States, except as a punishment for crime whereof the parties shall have been duly convicted. It thus not only prohibited states from themselves enslaving persons, but also obligated them to end enslavement by private individuals within their borders. Its framers viewed the text broadly, arguing that it allowed Congress to legislate not merely against slavery itself, but against all the badges and relics of a slave system. The amendment also authorized Congress to enforce its terms by appropriate legislation, authority not granted in any prior amendment. Proponents believe this enforcement clause permitted legislative measures designed to accomplish the amendment's broader goal of equality for the freedmen. It quickly became clear, however, that further amendment would be necessary to safeguard that goal. Soon after the 13th Amendment's adoption, the reconstructed Southern states began to enact black codes, which circumscribed the newly won freedoms of blacks. The Black Code of Mississippi, for example, imposed all sorts of disabilities on blacks, including limiting their freedom of movement and barring them from following certain occupations, owning firearms, serving on juries, testifying in cases involving whites, or voting. Congress responded with the landmark Civil Rights Act of 1866, in an attempt to preempt the black codes. The 1866 Act promised such a sweeping form of equality that it would lead many to say that it exceeded the scope of Congress's authority under the 13th Amendment. As enacted, it stated, "Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States and such citizens, of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the parties shall have been duly convicted, shall have the same right, in every state and territory in the United States, to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to none other, any law, statute, ordinance, regulation, or custom, to the contrary." Notwithstanding the text of the provision left no doubt as to its aim, all persons born in the United States were equal citizens entitled to the same rights and subject to the same penalties as white citizens in the categories enumerated. And, while the 1866 Act used the rights of white citizens as a benchmark, its rule was decidedly colorblind, safeguarding legal equality for all citizens, of every race and color, and providing the same rights to all. The 1866 Act's evolution further highlights its rule of equality. To start, Dred Scott v. Sanford had previously held that blacks were not regarded as a portion of the people or citizens of the government, and had no rights which the white man was bound to respect. The Act, however, would effectively overrule Dred Scott and ensure the equality that had been promised to blacks. But the Act went further still. On January 29, 1866, Senator Lyman Trumbull, the bill's principal sponsor in the Senate, proposed text stating that all persons of African descent born in the United States are hereby declared to be citizens. The following day, Trumbull revised his proposal, removing the reference to African descent and declaring more broadly that all persons born in the United States, and not subject to any foreign power, are citizens of the United States. In the years before the 14th Amendment's adoption, jurists and legislators often connected citizenship with equality, where the absence or presence of one entailed the absence or presence of the other. The addition of a citizenship guarantee thus evidenced an intent to broaden the provision, extending beyond recently freed blacks and incorporating a more general view of equality for all Americans. Indeed, the drafters later included a specific carve-out for Indians not taxed, demonstrating the breadth of the bill's otherwise general citizenship language. As Trumbull explained, the provision created a bond between all Americans. Any statute which is not equal to all, and which deprives any citizen of civil rights which are secured to other citizens, was an unjust encroachment upon his liberty, and a badge of servitude prohibited by the Constitution. At 474. Trumbull and most of the Act's other supporters identified the 13th Amendment as a principal source of constitutional authority for the Act's non-discrimination provisions. In particular, they explained that the 13th Amendment allowed Congress not merely to legislate against slavery itself, but also to counter measures which deprive any citizen of civil rights which are secured to other citizens. But opponents argued that Congress's authority did not sweep so broadly. President Andrew Johnson, for example, contended that Congress lacked authority to pass the measure, seizing on the breadth of the citizenship text and emphasizing state authority over matters of state citizenship. Consequently, doubts about the constitutional authority conferred by that measure led supporters to supplement their 13th Amendment arguments with other sources of constitutional authority. As debates continued, it became increasingly apparent that safeguarding the 1866 Act, including its promise of black citizenship and the equal rights that citizenship entailed, would require further submission to the people of the United States in the form of a proposed constitutional amendment. Critically, many of those who believed that Congress lacked the authority to enact the 1866 Act also supported the principle of racial equality. So, almost immediately following the ratification of the 13th Amendment, several proposals for further amendments were submitted in Congress. One such proposal, approved by the Joint Committee on Reconstruction and then submitted to the House of Representatives on February 26, 1866, would have declared that, "The Congress shall have power to make all laws which shall be necessary and proper to secure to the citizens of each state all privileges and immunities of citizens in the several states, and to all persons in the several states equal protection in the rights of life, liberty, and property." Representative John Bingham, its drafter, was among those who believed Congress lacked the power to enact the 1866 Act. Specifically, he believed that the very letter of the Constitution already required equality, but the enforcement of that requirement is of the reserved powers of the states. His proposed constitutional amendment accordingly would provide a clear constitutional basis for the 1866 Act and ensure that future Congresses would be unable to repeal it. Discussion of Bingham's initial draft was later postponed in the House, but the Joint Committee on Reconstruction continued its work. In April, Representative Thaddeus Stevens proposed to the Joint Committee an amendment that began, "No discrimination shall be made by any state nor by the United States as to the civil rights of persons because of race, color, or previous condition of servitude." Stevens' proposal was later revised to read as follows: "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." This revised text was submitted to the full House on April 30, 1866. Like the eventual first section of the 14th Amendment, this proposal embodied the familiar privileges or immunities, due process, and equal protection clauses. And, importantly, it also featured an enforcement clause, with text borrowed from the 13th Amendment, conferring upon Congress the power to enforce its provisions. Stevens explained that the draft was intended to allow Congress to correct the unjust legislation of the states, so far that the law which operates upon one man shall operate equally upon all. Moreover, Stevens' later statements indicate that he did not believe there was a difference in substance between the new proposal and earlier measures calling for impartial and equal treatment without regard to race. And Bingham argued that the need for the proposed text was one of the lessons that have been taught by the history of the past 4 years of terrific conflict during the Civil War. The proposal passed the House by a vote of 128 to 37. Senator Jacob Howard introduced the proposed amendment in the Senate, powerfully asking, "Ought not the time to be now past when one measure of justice is to be meted out to a member of one caste while another and a different measure is meted out to the member of another caste, both castes being alike citizens of the United States, both bound to obey the same laws, to sustain the burdens of the same government, and both equally responsible to justice and to God for the deeds done in the body?" In keeping with this view, he proposed an introductory sentence, declaring that all persons born in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the states wherein they reside. This text, the Citizenship Clause, was the final missing element of what would ultimately become of the 14th Amendment. Howard's draft for the proposed citizenship text was modeled on the Civil Rights Act of 1866's text, and he suggested the alternative language to remove all doubt as to what persons are or are not citizens of the United States, a question which had long been a great desideratum in the jurisprudence and legislation of this country. He further characterized the addition as simply declaratory of what I regard as the law of the land already. The proposal was approved in the Senate by a vote of 33 to 11. The House then reconciled differences between the two measures, approving the Senate's changes by a vote of 120 to 32. And, in June 1866, the amendment was submitted to the states for their consideration and ratification. 2 years later, it was ratified by the requisite number of states and became the 14th Amendment to the United States Constitution. Its opening words instilled in our nation's Constitution a new birth of freedom. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. As enacted, the text of the 14th Amendment provides a firm statement of equality before the law. It begins by guaranteeing citizenship status, invoking the long-standing political and legal tradition that closely associated the status of citizenship with the entitlement to legal equality. It then confirms that states may not abridge the rights of national citizenship, including whatever civil equality is guaranteed to citizens under the Citizenship Clause. Finally, it pledges that even non-citizens must be treated equally, as individuals, and not as members of racial, ethnic, or religious groups. The drafters and ratifiers of the 14th Amendment focused on this broad equality idea, offering surprisingly little explanation of which term was intended to accomplish which part of the amendment's overall goal. The available materials show, however, that there were widespread expressions of a general understanding of the broad scope of the amendment similar to that abundantly demonstrated in the congressional debates, namely, that the first section of the amendment would establish the full constitutional right of all persons to equality before the law and would prohibit legal distinctions based on race or color. For example, the Pennsylvania debate suggests that the 14th Amendment was understood to make the law, what justice is represented to be, blind to the color of one's skin. The most commonly held view today, consistent with the rationale repeatedly invoked during the congressional debates, e.g., is that the amendment was designed to remove any doubts regarding Congress's authority to enact the Civil Rights Act of 1866 and to establish a non-discrimination rule that could not be repealed by future Congresses. The amendment's phrasing supports this view, and there does not appear to have been any argument to the contrary predating Brown. Consistent with the Civil Rights Act of 1866's aim, the amendment definitively overruled Chief Justice Taney's opinion in Dred Scott that blacks were not regarded as a portion of the people or citizens of the government, and had no rights which the white man was bound to respect. And, like the 1866 Act, the amendment also clarified that American citizenship conferred rights not just against the federal government but also the government of the citizen's state of residence. Unlike the Civil Rights Act, however, the amendment employed a wholly race-neutral text, extending privileges or immunities to all citizens, even if its practical effect was to provide all citizens with the same privileges then enjoyed by whites. That citizenship guarantee was often linked with the concept of equality. Combining the citizenship guarantee with the Privileges or Immunities Clause and the Equal Protection Clause, the 14th Amendment ensures protection for all equal citizens of the nation without regard to race. Put succinctly, our Constitution is colorblind. In the period closely following the 14th Amendment's ratification, Congress passed several statutes designed to enforce its terms, eliminating government-based black codes, systems of government-imposed segregation, and criminalizing racially motivated violence. The marquee legislation was the Civil Rights Act of 1875, and the justifications offered by proponents of that measure are further evidence for the colorblind view of the 14th Amendment. The Civil Rights Act of 1875 sought to counteract the systems of racial segregation that had arisen in the wake of the Reconstruction era. Advocates of so-called separate but equal systems, which allowed segregated facilities for blacks and whites, had argued that laws permitting or requiring such segregation treated members of both races precisely alike. Blacks could not attend a white school, but symmetrically, whites could not attend a black school. C. Plessy, arguing that, in light of the social circumstances at the time, racial segregation did not necessarily imply the inferiority of either race to the other. Congress was not persuaded. Supporters of the soon-to-be 1875 Act successfully countered that symmetrical restrictions did not constitute equality, and they did so on colorblind terms. For example, they asserted that free government demands the abolition of all distinctions founded on color and race. And they submitted that the time has come when all distinctions that grew out of slavery ought to disappear. Leading Republican Senator Charles Sumner compellingly argued that any rule excluding a man on account of his color is an indignity, an insult, and a wrong. Far from conceding that segregation would be perceived as inoffensive if race roles were reversed, he declared that, "This is plain oppression, which you would feel keenly were it directed against you or your child." He went on to paraphrase the English common law rule to which he subscribed: "The law makes no discrimination on account of color." Others echoed this view. Representative John Lynch declared that, "The duty of the lawmaker is to know no race, no color, no religion, no nationality, except to prevent distinctions on any of these grounds, so far as the law is concerned." Senator John Sherman believed that the route to peace was to wipe out all legal discriminations between white and black and make no distinction between black and white. And Senator Henry Wilson sought to make illegal all distinctions on account of color, because there should be no distinction recognized by the laws of the land. The view of the legislature was clear: the Constitution neither knows nor tolerates classes among citizens. The earliest Supreme Court opinions to interpret the 14th Amendment did so in colorblind terms. Their statements characterizing the amendment evidence its commitment to equal rights for all citizens, regardless of the color of their skin. In the slaughterhouse cases, the court identified the pervading purpose of the Reconstruction Amendments as the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made freeman and citizen from the oppressions of those who had formerly exercised unlimited dominion over him. Yet, the court quickly acknowledged that the language of the amendments did not suggest that no one else but the Negro can share in this protection. Rather, if Mexican peonage or the Chinese coolie labor system shall develop slavery of the Mexican or Chinese race within our territory, the 13th Amendment may safely be trusted to make it void. And, similarly, if other rights are assailed by the states which properly and necessarily fall within the protection of these articles, that protection will apply, though the party interested may not be of African descent. The court thus made clear that the 14th Amendment's equality guarantee applied to members of all races, including Asian Americans, ensuring all citizens equal treatment under law. 7 years later, the court relied on the slaughterhouse view to conclude that the words of the 14th Amendment contain a necessary implication of a positive immunity or right, most valuable to the colored race, the right to exemption from unfriendly legislation against them distinctively as colored. The court thus found that the 14th Amendment banned express racial classifications, no matter the race affected, because these classifications are a stimulant to race prejudice. Similar statements appeared in other cases decided around that time. See Virginia v. Rives. The plain object of these statutes enacted to enforce the 14th Amendment, as of the Constitution which authorized them, was to place the colored race, in respect of civil rights, upon a level with whites. They made the rights and responsibilities, civil and criminal, of the two races exactly the same. Ex parte Virginia. One great purpose of the 13th and 14th Amendments was to raise the colored race from that condition of inferiority and servitude in which most of them had previously stood, into perfect equality of civil rights with all other persons within the jurisdiction of the states. This court's view of the 14th Amendment reached its nadir in Plessy, infamously concluding that the 14th Amendment could not have been intended to abolish distinctions based upon color, or to enforce social, as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. That holding stood in sharp contrast to the court's earlier embrace of the 14th Amendment's equality ideal. As Justice Harlan emphasized in dissent, the Reconstruction Amendments had aimed to remove the race line from our systems of governments. For Justice Harlan, the Constitution was colorblind and categorically rejected laws designed to protect a dominant race, a superior class of citizens, while imposing a badge of servitude on others. History has vindicated Justice Harlan's view, and this court recently acknowledged that Plessy should have been overruled immediately because it betrayed our commitment to equality before the law. Nonetheless, and despite Justice Harlan's efforts, the era of state-sanctioned segregation persisted for more than a half-century. Despite the extensive evidence favoring the colorblind view, as detailed above, it appears increasingly in vogue to embrace an anti-subordination view of the 14th Amendment, that the amendment forbids only laws that hurt, but not help, blacks. Such a theory lacks any basis in the original meaning of the 14th Amendment. Respondents cite a smattering of federal and state statutes passed during the years surrounding the ratification of the 14th Amendment. And, Justice Sotomayor's dissent argues that several of these statutes evidence the ratifiers' understanding that the Equal Protection Clause permits consideration of race to achieve its goal. Upon examination, however, it is clear that these statutes are fully consistent with the colorblind view. Start with the Freedmen's Bureau Act. That act established the Freedmen's Bureau to issue provisions, clothing, and fuel needful for the immediate and temporary shelter and supply of destitute and suffering refugees and freedmen and their wives and children, and the setting apart, for the use of loyal refugees and freedmen, abandoned, confiscated, or purchased lands, and assigning, to every male citizen, whether refugee or freedman, not more than 40 acres of such land. The Freedmen's Bureau Act then expanded upon the prior year's law, authorizing the Bureau to care for all loyal refugees and freedmen. Importantly, however, the acts applied to freedmen and refugees, a formally race-neutral category, not blacks writ large. And, because not all blacks in the United States were former slaves, freedmen was a decidedly inclusive proxy for race. Moreover, the Freedmen's Bureau served newly freed slaves alongside white refugees. And, advocates of the law explicitly disclaimed any view rooted in modern conceptions of anti-subordination. To the contrary, they explicitly clarified that the equality sought by the law was not one in which all men shall be 6 feet high, rather, it strove to ensure that freedmen enjoy equal rights before the law, such that each man shall have the right to pursue in his own way life, liberty, and happiness. Several additional federal laws cited by respondents appear to classify based on race, rather than previous condition of servitude. For example, an 1866 law adopted special rules and procedures for the payment of colored servicemen in the Union Army to agents who helped them secure bounties, pensions, and other payments that they were due. At the time, however, Congress believed that many black servicemen were significantly overpaying for these agent services in part because the servicemen did not understand how the payment system operated. Thus, while this legislation appears to have provided a discrete race-based benefit, its aim, to prohibit race-based exploitation, may not have been possible at the time without using a racial screen. In other words, the statute's racial classifications may well have survived strict scrutiny. Another law, passed in 1867, provided funds for freedmen or destitute colored people in the District of Columbia. However, when a prior version of this law targeting only blacks was criticized for being racially discriminatory, it was defended on the grounds that there were various places in the city where former slaves lived in densely populated shantytowns. Congress thus may have enacted the measure not because of race, but rather to address a special problem in shantytowns in the district where blacks lived. These laws, even if targeting race as such, likely were also constitutionally permissible examples of government action, undoing the effects of past discrimination in a way that does not involve classification by race, even though they had a racially disproportionate impact. Richmond v. Croson Company. The government can plainly remedy a race-based injury that it has inflicted, though such remedies must be meant to further a colorblind government, not perpetuate racial consciousness. In that way, race-based government measures during the 1860s and 1870s to remedy state-enforced slavery were not inconsistent with the colorblind Constitution. Moreover, the very same Congress passed both these laws and the unambiguously worded Civil Rights Act of 1866 that clearly prohibited discrimination on the basis of race. And, as noted above, the proponents of these laws explicitly sought equal rights without regard to race while disavowing any anti-subordination view. Justice Sotomayor argues otherwise, pointing to a number of race-conscious, federal laws passed around the time of the 14th Amendment's enactment. Post. She identifies the Freedmen's Bureau Act of 1865, already discussed above, as one such law, but she admits that the programs did not benefit blacks exclusively. She also does not dispute that legislation targeting the needs of newly freed blacks in 1865 could be understood as directly remedial. Even today, nothing prevents the states from according an admissions preference to identified victims of discrimination. See Crowson, Opinion of Scalia, J. While most of the beneficiaries might be black, neither the beneficiaries nor those disadvantaged by the preference would be identified on the basis of their race, emphasis in original. Justice Sotomayor points also to the Civil Rights Act of 1866, which as discussed above, mandated that all citizens have the same rights as those enjoyed by white citizens. But these references to the station of white citizens do not refute the view that the 14th Amendment is colorblind. Rather, they specify that, in meeting the amendment's goal of equal citizenship, states must level up. The act did not single out a group of citizens for special treatment. Rather, all citizens were meant to be treated the same as those who, at the time, had the full rights of citizenship. Other provisions of the 1866 Act reinforce this view, providing for equality in civil rights. Most notably stated that the basic civil rights of citizenship shall be secured, without respect to race or color. And, required that funds from land sales must be used to support schools, without distinction of color or race, in the parishes of the area where the land had been sold. In addition to these federal laws, Harvard also points to two state laws, a South Carolina statute that placed the burden of proof on the defendant when a colored or black plaintiff claimed a violation, and Kentucky legislation that authorized a county superintendent to aid Negro paupers in Mercer County. Even if these statutes provided race-based benefits, they do not support respondents and Justice Sotomayor's view that the 14th Amendment was contemporaneously understood to permit differential treatment based on race, prohibiting only caste legislation while authorizing antisubordination measures. At most, these laws would support the kinds of discrete remedial measures that our precedents have permitted. If services had been given only to white persons up to the 14th Amendment's adoption, then providing those same services only to previously excluded black persons would work to equalize treatment against a concrete baseline of government-imposed inequality. It thus may have been the case that Kentucky's county-specific, race-based public aid law was necessary because that particular county was not providing certain services to local poor blacks. Similarly, South Carolina's burden-shifting framework, where the substantive rule being applied remained notably race-neutral, may have been necessary to streamline litigation around the most commonly litigated type of case, a lawsuit seeking to remedy discrimination against a member of the large population of recently freed black Americans. Most importantly, however, there was a wide range of federal and state statutes enacted at the time of the 14th Amendment's adoption and during the period thereafter that explicitly sought to discriminate against blacks on the basis of race or a proxy for race. These laws, hallmarks of the race-conscious Jim Crow era, are precisely the sort of enactments that the framers of the 14th Amendment sought to eradicate. Yet, proponents of an anti-subordination view necessarily do not take those laws as evidence of the 14th Amendment's true meaning. And rightly so. Neither those laws, nor a small number of laws that appear to target blacks for preferred treatment, displace the equality vision reflected in the history of the 14th Amendment's enactment. This is particularly true in light of the clear equality requirements present in the 14th Amendment's text. Properly understood, our precedents have largely adhered to the 14th Amendment's demand for colorblind laws. That is why, for example, courts must subject all racial classifications to the strictest of scrutiny. Jenkins and, in case after case, we have employed strict scrutiny vigorously to reject various forms of racial discrimination as unconstitutional. C. Fisher. The court today rightly upholds that tradition and acknowledges the consequences that have flowed from Grutter's contrary approach. Three aspects of today's decision warrant comment. First, to satisfy strict scrutiny, universities must be able to establish an actual link between racial discrimination and educational benefits. Second, those engaged in racial discrimination do not deserve deference with respect to their reasons for discriminating. Third, attempts to remedy past governmental discrimination must be closely tailored to address that particular past governmental discrimination. To satisfy strict scrutiny, universities must be able to establish a compelling reason to racially discriminate. Grutter recognized only one interest sufficiently compelling to justify race-conscious admissions programs, the educational benefits of a diverse student body. Expanding on this theme, Harvard and UNC have offered a grab bag of interests to justify their programs, spanning from training future leaders in the public and private sectors, to enhancing appreciation, respect, and empathy, with references to better educating their students through diversity, in between. The court today finds that each of these interests are too vague and immeasurable to suffice, and I agree. Even in Grutter, the court failed to clearly define the educational benefits of a diverse student body. Thus, in the years since Grutter, I have sought to understand exactly how racial diversity yields educational benefits. With nearly 50 years to develop their arguments, neither Harvard nor UNC, two of the foremost research institutions in the world, nor any of their amici can explain that critical link. Harvard, for example, offers a report finding that meaningful representation of racial minorities promotes several goals. Only one of those goals, producing new knowledge stemming from diverse outlooks, bears any possible relationship to educational benefits. Yet, it too is extremely vague and offers no indication that, for example, student test scores increased as a result of Harvard's efforts toward racial diversity. More fundamentally, it is not clear how racial diversity, as opposed to other forms of diversity, uniquely and independently advances Harvard's goal. This is particularly true because Harvard blinds itself to other forms of applicant diversity, such as religion. It may be the case that exposure to different perspectives and thoughts can foster debate, sharpen young minds, and hone students' reasoning skills. But it is not clear how diversity with respect to race, qua race, furthers this goal. Two white students, one from rural Appalachia and one from a wealthy San Francisco suburb, may well have more diverse outlooks on this metric than two students from Manhattan's Upper East Side attending its most elite schools, one of whom is white and other of whom is black. If Harvard cannot even explain the link between racial diversity and education, then surely its interest in racial diversity cannot be compelling enough to overcome the constitutional limits on race consciousness. UNC fares no better. It asserts, for example, an interest in training students to live together in a diverse society. This may well be important to a university experience, but it is a social goal, not an educational one. And, again, UNC offers no reason why seeking a diverse society would not be equally supported by admitting individuals with diverse perspectives and backgrounds, rather than varying skin pigmentation. Nor have amici pointed to any concrete and quantifiable educational benefits of racial diversity. The United States focuses on alleged civic benefits, including increasing tolerance and decreasing racial prejudice. Yet, when it comes to educational benefits, the government offers only one study purportedly showing that college diversity experiences are significantly and positively related to cognitive development, and that interpersonal interactions with racial diversity are the most strongly related to cognitive development. Here again, the link is, at best, tenuous, unspecific, and stereotypical. Other amici assert that diversity, generally, fosters the even more nebulous values of creativity and innovation, particularly in graduates' future workplaces. Yet, none of those assertions deals exclusively with racial diversity, as opposed to cultural or ideological diversity. And, none of those amici demonstrate measurable or concrete benefits that have resulted from universities' race-conscious admissions programs. Of course, even if these universities had shown that racial diversity yielded any concrete or measurable benefits, they would still face a very high bar to show that their interest is compelling. To survive strict scrutiny, any such benefits would have to outweigh the tremendous harm inflicted by sorting individuals on the basis of race. As the court's opinions in these cases make clear, all racial stereotypes harm and demean individuals. That is why, only those measures the state must take to provide a bulwark against anarchy, or to prevent violence, will constitute a pressing public necessity, sufficient to satisfy strict scrutiny today. For this reason, just as the alleged educational benefits of segregation were insufficient to justify racial discrimination in the 1950s, see Brown v. Board of Education, the alleged educational benefits of diversity cannot justify racial discrimination today. The court also correctly refuses to defer to the university's own assessments that the alleged benefits of race-conscious admissions programs are compelling. It instead demands that the interests universities view as compelling must be capable of being subjected to meaningful judicial review. In other words, a court must be able to measure the goals asserted and determine when they have been reached. The court's opinion today further insists that universities must be able to articulate a meaningful connection between the means they employ and the goals they pursue. Universities' self-proclaimed righteousness does not afford them license to discriminate on the basis of race. In fact, it is error for a court to defer to the views of an alleged discriminator while assessing claims of racial discrimination. We would not offer such deference in any other context. In employment discrimination lawsuits under Title VII of the Civil Rights Act, for example, courts require only a minimal prima facie showing by a complainant before shifting the burden onto the shoulders of the alleged discriminator employer. And, Congress has passed numerous laws, such as the Civil Rights Act of 1875, under its authority to enforce the 14th Amendment, each designed to counter discrimination and each relying on courts to bring a skeptical eye to alleged discriminators. This judicial skepticism is vital. History has repeatedly shown that purportedly benign discrimination may be pernicious, and discriminators may go to great lengths to hide and perpetuate their unlawful conduct. Take, for example, the university respondents here. Harvard's holistic admissions policy began in the 1920s when it was developed to exclude Jews. Based on de facto quotas that Harvard quietly implemented, the proportion of Jews in Harvard's freshman class declined from 28% as late as 1925 to just 12% by 1933. During this same period, Harvard played a prominent role in the eugenics movement. According to then-President Abbott Lawrence Lowell, excluding Jews from Harvard would help maintain admissions opportunities for Gentiles and perpetuate the purity of the Brahmin race, New England's white, Protestant upper crust. UNC also has a checkered history, dating back to its time as a segregated university. It admitted its first black undergraduate students in 1955, but only after being ordered to do so by a court, following a long legal battle in which UNC sought to keep its segregated status. Even then, UNC did not turn on a dime. The first 3 black students admitted as undergraduates enrolled at UNC but ultimately earned their bachelor's degrees elsewhere. To the extent past is prologue, the university respondents' histories hardly recommend them as trustworthy arbiters of whether racial discrimination is necessary to achieve educational goals. Of course, none of this should matter in any event. Courts have an independent duty to interpret and uphold the Constitution that no university's claimed interest may override. The court today makes clear that, in the future, universities wishing to discriminate based on race in admissions must articulate and justify a compelling and measurable state interest based on concrete evidence. Given the strictures set out by the court, I highly doubt any will be able to do so. In an effort to salvage their patently unconstitutional programs, the universities and their amici pivot to argue that the 14th Amendment permits the use of race to benefit only certain racial groups, rather than applicants writ large. Yet, this is just the latest disguise for discrimination. The sudden narrative shift is not surprising, as it has long been apparent that diversity was merely the current rationale of convenience to support racially discriminatory admissions programs. Under our precedents, this new rationale is also lacking. To start, the case for affirmative action has emphasized a number of rationales over the years, including 1. Restitution to compensate those who have been victimized by past discrimination, 2. Fostering diversity, 3. Facilitating integration and the destruction of perceived racial castes, and 4. Countering long-standing and diffuse racial prejudice. Again, this court has only recognized one interest as compelling, the educational benefits of diversity embraced in Grutter. Yet, as the universities define the diversity that they practice, it encompasses social and aesthetic goals far afield from the education-based interest discussed in Grutter. The dissents too attempt to stretch the diversity rationale, suggesting that it supports broad remedial interests. Post, opinion of Sotomayor, J. Noting that UNC's black admissions percentages do not reflect the diversity of the state, equating the diversity interest under the court's precedents with a goal of integration in higher education more broadly, and warning of the dangerous consequences of an America where its leadership does not reflect the diversity of the people. Post, opinion of Jackson, J. Explaining that diversity programs close wealth gaps. But language, particularly the language of controlling opinions of this court, is not so elastic. See Piper, Abuse of Language, Abuse of Power 23, explaining that propaganda, in contradiction to the nature of language, intends not to communicate but to manipulate, and becomes an instrument of power. The court refuses to engage in this lexicographic drift, seeing these arguments for what they are, a remedial rationale in disguise. As the court points out, the interest for which respondents advocate has been presented to and rejected by this court many times before. In Regents of University of California v. Bakke, the University of California made clear its rationale for the quota system it had established. It wished to counteract effects of generations of pervasive discrimination against certain minority groups. But, the court rejected this distinctly remedial rationale, with Justice Powell adopting in its place the familiar diversity interest that appeared later in Grutter. The court similarly did not adopt the broad remedial rationale in Grutter, and it rejects it again today. Newly and often minted theories cannot be said to be commanded by our precedents. Indeed, our precedents have repeatedly and soundly distinguished between programs designed to compensate victims of past governmental discrimination from so-called benign race-conscious measures, such as affirmative action. To enforce that distinction, our precedents explicitly require that any attempt to compensate victims of past governmental discrimination must be concrete and traceable to the de jure segregated system, which must have some discrete and continuing discriminatory effect that warrants a present remedy. Today's opinion for the court reaffirms the need for such a close remedial fit, hewing to the same line we have consistently drawn. Ante. Without such guardrails, the 14th Amendment would become self-defeating, promising a nation based on the equality ideal but yielding a quota and caste-ridden society steeped in race-based discrimination. Even Grutter itself could not tolerate this outcome. It accordingly imposed a time limit for its race-based regime, observing that a core purpose of the 14th Amendment was to do away with all governmentally imposed discrimination based on race. The court today enforces those limits. And rightly so. As noted above, both Harvard and UNC have a history of racial discrimination. But, neither have even attempted to explain how their current racially discriminatory programs are even remotely traceable to their past discriminatory conduct. Nor could the current race-conscious admissions programs take no account of ancestry and, at least for Harvard, likely have the effect of discriminating against some of the very same ethnic groups against which Harvard previously discriminated, i.e. Jews and those who are not part of the white elite. All the while, Harvard and UNC ask us to blind ourselves to the burdens imposed on the millions of innocent applicants denied admission because of their membership in a currently disfavored race. The Constitution neither commands nor permits such a result. Purchased at the price of immeasurable human suffering, the 14th Amendment recognizes that classifications based on race lead to ruinous consequences for individuals and the nation. Consequently, all racial classifications are inherently suspect. Both experience and logic have vindicated the Constitution's colorblind rule and confirmed that the university's new narrative cannot stand. Despite the court's hope in Grutter that universities would voluntarily end their race-conscious programs and further the goal of racial equality, the opposite appears increasingly true. Harvard and UNC now forthrightly state that they racially discriminate when it comes to admitting students, arguing that such discrimination is consistent with this court's precedents. And they, along with today's dissenters, defend that discrimination is good. More broadly, it is becoming increasingly clear that discrimination on the basis of race, often packaged as affirmative action or equity programs, are based on the benighted notion that it is possible to tell when discrimination helps, rather than hurts, racial minorities. Fisher, we cannot be guided by those who would desire less in our Constitution, or by those who would desire more. The Constitution abhors classifications based on race, not only because those classifications can harm favored races or are based on illegitimate motives,
but also because every time the government places citizens on racial registers and makes race relevant to the provision of burdens or benefits, it demeans us all. Grutter, Opinion of Thomas, J. The Constitution's colorblind rule reflects one of the core principles upon which our nation was founded, that all men are created equal. Those words featured prominently in our Declaration of Independence and were inspired by a rich tradition of political thinkers, from Locke to Montesquieu, who considered equality to be the foundation of a just government. Several constitutions enacted by the newly independent states at the founding reflected this principle. For example, the Virginia Bill of Rights of 1776 explicitly affirmed that all men are by nature equally free and independent, and have certain inherent rights. The state constitutions of Massachusetts, Pennsylvania, and New Hampshire adopted similar language. And prominent founders publicly mused about the need for equality as the foundation for government. As Jefferson declared in his first inaugural address, the minority possess their equal rights, which equal law must protect. Our nation did not initially live up to the equality principle. The institution of slavery persisted for nearly a century, and the United States Constitution itself included several provisions acknowledging the practice. The period leading up to our second founding brought these flaws into bold relief and encouraged the nation to finally make good on the equality promise. As Lincoln recognized, the promise of equality extended to all people, including immigrants and blacks whose ancestors had taken no part in the original founding. Thus, in Lincoln's view, the natural rights enumerated in the Declaration of Independence extended to blacks as his equal, and the equal of every living man. The Lincoln-Douglas Debates 285. As discussed above, the 14th Amendment reflected that vision, affirming that equality and racial discrimination cannot coexist. Under that amendment, the color of a person's skin is irrelevant to that individual's equal status as a citizen of this nation. To treat him differently on the basis of such a legally irrelevant trait is therefore a deviation from the equality principle and a constitutional injury. Of course, even the promise of the second founding took time to materialize. Seeking to perpetuate a segregationist system in the wake of the 14th Amendment's ratification, proponents urged a separate but equal regime. They met with initial success, ossifying the segregationist view for over a half-century. As this court said in Plessy, a statute which implies merely a legal distinction between the white and colored races, a distinction which is founded in the color of the two races, and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of the two races, or re-establish a state of involuntary servitude. Such a statement, of course, is precisely antithetical to the notion that all men, regardless of the color of their skin, are born equal and must be treated equally under the law. Only one member of the court adhered to the equality principle. Justice Harlan, standing alone in dissent, wrote, "Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law." Though Justice Harlan rightly predicted that Plessy would, in time, prove to be quite as pernicious as the decision made in the Dred Scott case, the Plessy rule persisted for over a half-century. While it remained in force, Jim Crow laws prohibiting blacks from entering or utilizing public facilities such as schools, libraries, restaurants, and theaters sprang up across the South. This court rightly reversed course in Brown v. Board of Education. The Brown appellants, those challenging segregated schools, embraced the equality principle, arguing that a racial criterion is a constitutional irrelevance, and is not saved from condemnation even though dictated by a sincere desire to avoid the possibility of violence or race friction. Embracing that view, the court held that, in the field of public education, the doctrine of separate but equal has no place, and separate educational facilities are inherently unequal. Importantly, in reaching this conclusion, Brown did not rely on the particular qualities of the Kansas schools. The mere separation of students on the basis of race, the segregation complained of, constituted a constitutional injury. Separate cannot be equal. Just a few years later, the court's application of Brown made explicit what was already forcefully implied:
our decisions have foreclosed any possible contention that a statute or regulation, fostering segregation in public facilities, may stand consistently with the 14th Amendment. Blaustein and Ferguson, Desegregation and the Law, The Meaning and Effect of the School Segregation Cases 145. Today, our precedents place this principle beyond question. In assessing racial segregation during a race-motivated prison riot, for example, this court applied strict scrutiny without requiring an allegation of unequal treatment among the segregated facilities. The court today reaffirms the rule, stating that, following Brown, the time for making distinctions based on race had passed. What was wrong when the court decided Brown, in 1954 cannot be right today. Rather, we must adhere to the promise of equality under the law declared by the Declaration of Independence and codified by the 14th Amendment. Respondents and the dissents argue that the university's race-conscious admissions programs ought to be permitted because they accomplish positive social goals. I would have thought that history had by now taught a greater humility when attempting to distinguish good from harmful uses of racial criteria. From the Black Codes, to discriminatory and destructive social welfare programs, to discrimination by individual government actors, bigotry has reared its ugly head time and again. Anyone who today thinks that some form of racial discrimination will prove helpful should thus tread cautiously, lest racial discriminators succeed, as they once did, in using such language to disguise more invidious motives. Arguments for the benefits of race-based solutions have proved pernicious in segregationist circles. Segregated universities once argued that race-based discrimination was needed to preserve harmony and peace and at the same time furnish equal education to both groups. And parties consistently attempted to convince the court that the time was not right to disrupt segregationist systems. Litigants have even gone so far as to offer straight-faced arguments that segregation has practical benefits. In fact, slaveholders once argued that slavery was a positive good that civilized blacks and elevated them in every dimension of life, and segregationists similarly asserted that segregation was not only benign, but good for black students. Indeed, if our history has taught us anything, it has taught us to beware of elites bearing racial theories. We cannot now blink reality to pretend, as the dissents urge, that affirmative action should be legally permissible merely because the experts assure us that it is good for black students. Though I do not doubt the sincerity of my dissenting colleagues' beliefs, experts and elites have been wrong before, and they may prove to be wrong again. In part for this reason, the 14th Amendment outlaws government-sanctioned racial discrimination of all types. The stakes are simply too high to gamble. Then, as now, the views that motivated Dred Scott and Plessy have not been confined to the past, and we must remain ever vigilant against all forms of racial discrimination. Even taking the desire to help on its face, what initially seems like aid may in reality be a burden, including for the very people it seeks to assist. Take, for example, the college admissions policies here. Affirmative action policies do nothing to increase the overall number of blacks and Hispanics able to access a college education. Rather, those racial policies simply redistribute individuals among institutions of higher learning, placing some into more competitive institutions than they otherwise would have attended. In doing so, those policies sort at least some blacks and Hispanics into environments where they are less likely to succeed academically relative to their peers. The resulting mismatch places many blacks and Hispanics who likely would have excelled at less elite schools in a position where underperformance is all but inevitable because they are less academically prepared than the white and Asian students with whom they must compete. Fisher, it is self-evident why that is so. As anyone who has labored over an algebra textbook has undoubtedly discovered, academic advancement results from hard work and practice, not mere declaration. Simply treating students as though their grades put them at the top of their high school classes does nothing to enhance the performance level of those students or otherwise prepare them for competitive college environments. In fact, studies suggest that large racial preferences for black and Hispanic applicants have led to a disproportionately large share of those students receiving mediocre or poor grades once they arrive in competitive collegiate environments. Take science, technology, engineering, and mathematics, STEM, fields, for example. Those students who receive a large admissions preference are more likely to drop out of STEM fields than similarly situated students who did not receive such a preference. Even if most minority students are able to meet the normal standards at the average range of colleges and universities, the systematic mismatching of minority students begun at the top can mean that such students are generally overmatched throughout all levels of higher education. These policies may harm even those who succeed academically. I have long believed that large racial preferences in college admissions stamp blacks and Hispanics with a badge of inferiority. They thus taint the accomplishments of all those who are admitted as a result of racial discrimination, as well as all those who are the same race as those admitted as a result of racial discrimination, because no one can distinguish those students from the ones whose race played a role in their admission. Consequently, when blacks and, now, Hispanics take positions in the highest places of government, industry, or academia, it is an open question whether their skin color played a part in their advancement. The question itself is the stigma, because either racial discrimination did play a role, in which case the person may be deemed otherwise unqualified, or it did not, in which case asking the question itself unfairly marks those who would succeed without discrimination. Yet, in the face of those problems, it seems increasingly clear that universities are focused on aesthetic solutions unlikely to help deserving members of minority groups. In fact, universities' affirmative action programs are a particularly poor use of such resources. To start, these programs are over-inclusive, providing the same admissions bump to a wealthy black applicant given every advantage in life as to a black applicant from a poor family with seemingly insurmountable barriers to overcome. In doing so, the programs may wind up helping the most well-off members of minority races without meaningfully assisting those who struggle with real hardship. Simultaneously, the programs risk continuing to ignore the academic underperformance of the purported beneficiaries of racial preferences and the racial stigma that those preferences generate. Rather than performing their academic mission, universities thus may seek only a facade. It is sufficient that the class looks right, even if it does not perform right. Finally, it is not even theoretically possible to help a certain racial group without causing harm to members of other racial groups. It should be obvious that every racial classification helps, in a narrow sense, some races and hurts others. And, even purportedly benign race-based discrimination has secondary effects on members of other races. The anti-subordination view thus has never guided the court's analysis because, whether a law relying upon racial taxonomy is benign or malign either turns on whose ox is gored or on distinctions found only in the eye of the beholder. Courts are not suited to the impossible task of determining which racially discriminatory programs are helping which members of which races, and whether those benefits outweigh the burdens thrust onto other racial groups. As the court's opinion today explains, the zero-sum nature of college admissions, where students compete for a finite number of seats in each school's entering class, aptly demonstrates the point. Petitioner here represents Asian Americans who allege that, at the margins, Asian applicants were denied admission because of their race. Yet, Asian Americans can hardly be described as the beneficiaries of historical racial advantages. To the contrary, our nation's first immigration ban targeted the Chinese, in part, based on worker resentment of the low wage rates accepted by Chinese workers. Commission on Civil Rights issues facing Asian Americans in the 1990s, Act of May 6, 1882, ch. 126. In subsequent years, strong anti-Asian sentiments in the Western states led to the adoption of many discriminatory laws at the state and local levels, similar to those aimed at blacks in the South, and segregation in public facilities, including schools, was quite common until after the Second World War. Indeed, this court even sanctioned this segregation, in the context of schools, no less. In Gong Lum v. Rice, the court held that a 9-year-old Chinese-American girl could be denied entry to a white school because she was a member of the Mongolian or yellow race. Also, following the Japanese attack on the Navy base at Pearl Harbor, Japanese Americans in the American West were evacuated and interned in relocation camps. Over 120,000 were removed to camps beginning in 1942, and the last camp that held Japanese Americans did not close until 1948. In the interim, this court endorsed the practice. Given the history of discrimination against Asian Americans, especially their history with segregated schools, it seems particularly incongruous to suggest that a past history of segregationist policies toward blacks should be remedied at the expense of Asian American college applicants. But this problem is not limited to Asian Americans more broadly. Universities' discriminatory policies burden millions of applicants who are not responsible for the racial discrimination that sullied our nation's past. That is why, in the absence of special circumstances, the remedy for de jure segregation ordinarily should not include educational programs for students who were not in school, or even alive, during the period of segregation. Today's 17-year-olds, after all, did not live through the Jim Crow era, enact or enforce segregation laws, or take any action to oppress or enslave the victims of the past. Whatever their skin color, today's youth simply are not responsible for instituting the segregation of the 20th century, and they do not shoulder the moral debts of their ancestors. Our nation should not punish today's youth for the sins of the past. Far from advancing the cause of improved race relations in our nation, affirmative action highlights our racial differences with pernicious effect. In fact, recent history reveals a disturbing pattern. Affirmative action policies appear to have prolonged the asserted need for racial discrimination. Parties and amici in these cases report that, in the nearly 50 years since Bakke, racial progress on campuses adopting affirmative action admissions policies has stagnated, including making no meaningful progress toward a colorblind goal since Grutter. Rather, the legacy of Grutter appears to be ever-increasing in strident demands for yet more racially oriented solutions. It has become clear that sorting by race does not stop at the admissions office. In his Grutter opinion, Justice Scalia criticized universities for talking of multiculturalism and racial diversity, but supporting tribalism and racial segregation on their campuses, including through minority-only student organizations, separate minority housing opportunities, separate minority student centers, even separate minority-only graduation ceremonies. This trend has hardly abated with time, and today, such programs are commonplace. In fact, a recent study considering 173 schools found that 43% of colleges offered segregated housing to students of different races, 46% offered segregated orientation programs, and 72% sponsored segregated graduation ceremonies. In addition to contradicting the university's claims regarding the need for interracial interaction, these trends increasingly encourage our nation's youth to view racial differences as important and segregation as routine. Meanwhile, these discriminatory policies risk creating new prejudices and allowing old ones to fester. I previously observed that there can be no doubt that discriminatory affirmative action policies injure white and Asian applicants who are denied admission because of their race. Petitioner here clearly demonstrates this fact. Moreover, no social science has disproved the notion that this discrimination engenders attitudes of superiority or, alternatively, provokes resentment among those who believe that they have been wronged by the government's use of race. Applicants denied admission to certain colleges may come to believe, accurately or not, that their race was responsible for their failure to attain a lifelong dream. These individuals, and others who wished for their success, may resent members of what they perceive to be favored races, believing that the successes of those individuals are unearned. What, then, would be the end point of these affirmative action policies? Not racial harmony, integration, or equality under the law. Rather, these policies appear to be leading to a world in which everyone is defined by their skin color, demanding ever-increasing entitlements and preferences on that basis. Not only is that exactly the kind of factionalism that the Constitution was meant to safeguard against, but it is a factionalism based on ever-shifting sands. That is because race is a social construct. We may each identify as members of particular races for any number of reasons, having to do with our skin color, our heritage, or our cultural identity. And, over time, these ephemeral, socially constructed categories have often shifted. For example, whereas universities today would group all white applicants together, white elites previously sought to exclude Jews and other white immigrant groups from higher education. In fact, it is impossible to look at an individual and know definitively his or her race. Some who would consider themselves black, for example, may be quite fair-skinned. Yet, university admissions policies ask individuals to identify themselves as belonging to one of only a few reductionist racial groups. With boxes for only black, white, Hispanic, Asian, or the ambiguous other, how is a Middle Eastern person to choose? Someone from the Philippines? Whichever choice he makes, in the event he chooses to report a race at all, the form silos him into an artificial category. Worse, it sends a clear signal that the category matters. But, under our Constitution, race is irrelevant, as the court acknowledges. In fact, all racial categories are little more than stereotypes, suggesting that immutable characteristics somehow conclusively determine a person's ideology, beliefs, and abilities. Of course, that is false. Members of the same race do not all share the exact same experiences and viewpoints, far from it. A black person from rural Alabama surely has different experiences than a black person from Manhattan or a black first-generation immigrant from Nigeria, in the same way that a white person from rural Vermont has a different perspective than a white person from Houston, Texas. Yet, universities' racial policies suggest that racial identity alone constitutes the being of the race or the man. That is the same naked racism upon which segregation itself was built. Small wonder, then, that these policies are leading to increasing racial polarization and friction. This kind of reductionist logic leads directly to the disregard for what does not jibe with preconceived theory, providing a cloak to conceal complexity, argument to the crown for praising or damning without the trouble of going into details, such as details about an individual's ideas or unique background. Rather than forming a more pluralistic society, these policies thus strip us of our individuality and undermine the very diversity of thought that universities purport to seek. The solution to our nation's racial problems thus cannot come from policies grounded in affirmative action or some other conception of equity. Racialism simply cannot be undone by different or more racialism. Instead, the solution announced in the Second Founding is incorporated in our Constitution, that we are all equal, and should be treated equally before the law without regard to our race. Only that promise can allow us to look past our differing skin colors and identities and see each other for what we truly are, individuals with unique thoughts, perspectives, and goals, but with equal dignity and equal rights under the law. Justice Jackson has a different view. Rather than focusing on individuals as individuals, her dissent focuses on the historical subjugation of Black Americans, invoking statistical racial gaps to argue in favor of defining and categorizing individuals by their race. As she sees things, we are all inexorably trapped in a fundamentally racist society, with the original sin of slavery and the historical subjugation of Black Americans still determining our lives today. The panacea, she counsels, is to unquestioningly accede to the view of elite experts and reallocate society's riches by racial means as necessary to level the playing field, all as judged by racial metrics. I strongly disagree. First, as stated above, any statistical gaps between the average wealth of Black and white Americans is constitutionally irrelevant. I, of course, agree that our society is not, and has never been, colorblind. People discriminate against one another for a whole host of reasons. But, under the 14th Amendment, the law must disregard all racial distinctions. In view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man, and takes no account of his surroundings or of his color when his civil rights as guaranteed by the supreme law of the land are involved. With the passage of the 14th Amendment, the people of our nation proclaimed that the law may not sort citizens based on race. It is this principle that the framers of the 14th Amendment adopted in the wake of the Civil War to fulfill the promise of equality under the law. And it is this principle that has guaranteed a nation of equal citizens the privileges or immunities of citizenship and the equal protection of the laws. To now dismiss it as two-dimensional flatness, post, is to abdicate a sacred trust to ensure that our honored dead shall not have died in vain. Yet, Justice Jackson would replace the Second Founder's vision with an organizing principle based on race. In fact, on her view, almost all of life's outcomes may be unhesitatingly ascribed to race. This is so, she writes, because of statistical disparities among different racial groups. Even if some whites have a lower household net worth than some blacks, what matters to Justice Jackson is that the average white household has more wealth than the average black household. This lore is not and has never been true. Even in the segregated South where I grew up, individuals were not the sum of their skin color. Then as now, not all disparities are based on race, not all people are racist, and not all differences between individuals are ascribable to race. Put simply, the fate of abstract categories of wealth statistics is not the same as the fate of a given set of flesh and blood human beings. Worse still, Justice Jackson uses her broad observations about statistical relationships between race and select measures of health, wealth, and well-being to label all blacks as victims. Her desire to do so is unfathomable to me. I cannot deny the great accomplishments of black Americans, including those who succeeded despite long odds. Nor do Justice Jackson's statistics regarding a correlation between levels of health, wealth, and well-being between selected racial groups prove anything. Of course, none of those statistics are capable of drawing a direct causal link between race, rather than socioeconomic status or any other factor, and individual outcomes. So Justice Jackson supplies the link herself, the legacy of slavery and the nature of inherited wealth. This, she claims, locks blacks into a seemingly perpetual inferior caste. Such a view is irrational. It is an insult to individual achievement and cancerous to young minds seeking to push through barriers, rather than consign themselves to permanent victimhood. If an applicant has less financial means, because of generational inheritance or otherwise, then surely a university may take that into account. If an applicant has medical struggles or a family member with medical concerns, a university may consider that too. What it cannot do is use the applicant's skin color as a heuristic, assuming that because the applicant checks the box for black, he therefore conforms to the university's monolithic and reductionist view of an abstract, average black person. Accordingly, Justice Jackson's race-infused worldview falls flat at each step. Individuals are the sum of their unique experiences, challenges, and accomplishments. What matters is not the barriers they face, but how they choose to confront them. And their race is not to blame for everything, good or bad, that happens in their lives. A contrary, myopic worldview based on individual skin color to the total exclusion of their personal choices is nothing short of racial determinism. Justice Jackson then builds from her faulty premise to call for action, arguing that courts should defer to experts and allow institutions to discriminate on the basis of race. Make no mistake, her dissent is not a vanguard of the innocent and helpless. It is instead a call to empower privileged elites, who will tell us what is required to level the playing field among castes and classifications that they alone can divine. See also post, explaining the arbitrariness of these classifications. Then, after siloing us all into racial castes and pitting those castes against each other, the dissent somehow believes that we will be able, at some undefined point, to march forward together into some utopian vision. Opinion of Jackson, J. Social movements that invoke these sorts of rallying cries, historically, have ended disastrously. Unsurprisingly, this tried and failed system defies both law and reason. Start with the obvious. If social reorganization in the name of equality may be justified by the mere fact of statistical disparities among racial groups, then that reorganization must continue until these disparities are fully eliminated, regardless of the reasons for the disparities and the cost of their elimination. If blacks fail a test at higher rates than their white counterparts, regardless of whether the reason for the disparity has anything at all to do with race, the only solution will be race-focused measures. If those measures were to result in blacks failing at yet higher rates, the only solution would be to double down. In fact, there would seem to be no logical limit to what the government may do to level the racial playing field. Outright wealth transfers, quota systems, and racial preferences would all seem permissible. In such a system, it would not matter how many innocents suffer race-based injuries, all that would matter is reaching the race-based goal. Worse, the classifications that Justice Jackson draws are themselves race-based stereotypes. She focuses on two hypothetical applicants, John and James, competing for admission to UNC. John is a white, seventh-generation legacy at the school, while James is black and would be the first in his family to attend UNC. Post. Justice Jackson argues that race-conscious admission programs are necessary to adequately compare the two applicants. As an initial matter, it is not clear why James's race is the only factor that could encourage UNC to admit him. His status as a first-generation college applicant seems to contextualize his application. But, setting that aside, why is it that John should be judged based on the actions of his great-great-great-grandparents? And what would Justice Jackson say to John when deeming him not as worthy of admission? Some statistically significant number of white people had advantages in college admissions 7 generations ago, and you have inherited their incurable sin. Nor should we accept that John or James represent all members of their respective races. All racial groups are heterogeneous, and blacks are no exception, encompassing Northerners and Southerners, rich and poor, and recent immigrants and descendants of slaves. Sowell, Ethnic America 220, noting that the great success of West Indian immigrants to the United States, disproportionate among blacks more broadly, seriously undermines the proposition that color is a fatal handicap in the American economy. Eschewing the complexity that comes with individuality may make for an uncomplicated narrative, but lumping people together and judging them based on assumed inherited or ancestral traits is nothing but stereotyping. To further illustrate, let's expand the applicant pool beyond John and James. Consider Jack, a black applicant and the son of a multimillionaire industrialist. In a world of race-based preferences, James' seat could very well go to Jack rather than John. Both are black, after all. And what about members of the numerous other racial and ethnic groups in our nation? What about Anne, the child of Chinese immigrants? Jacob, the grandchild of Holocaust survivors who escaped to this nation with nothing and faced discrimination upon arrival? Or Thomas, the great-grandchild of Irish immigrants escaping famine? While articulating her black and white world, literally, Justice Jackson ignores the experiences of other immigrant groups and white communities that have faced historic barriers. Though Justice Jackson seems to think that her race-based theory can somehow benefit everyone, it is an immutable fact that, every time the government uses racial criteria to bring the races together, someone gets excluded, and the person excluded suffers an injury solely because of his or her race. Indeed, Justice Jackson seems to have no response, no explanation at all, for the people who will shoulder that burden. How, for example, would Justice Jackson explain the need for race-based preferences to the Chinese student who has worked hard his whole life, only to be denied college admission in part because of his skin color? If such a burden would seem difficult to impose on a bright-eyed young person, that's because it should be. History has taught us to abhor theories that call for elites to pick racial winners and losers in the name of sociological experimentation. Nor is it clear what another few generations of race-conscious college admissions may be expected to accomplish. Even today, affirmative action programs that offer an admissions boost to Black and Hispanic students discriminate against those who identify themselves as members of other races that do not receive such preferential treatment. Must others in the future make sacrifices to re-level the playing field for this new phase of racial subordination? And then, out of whose lives should the debt owed to those further victims be repaid? This vision of meeting social racism with government-imposed racism is thus self-defeating, resulting in a never-ending cycle of victimization. There is no reason to continue down that path. In the wake of the Civil War, the framers of the 14th Amendment charted a way out, a colorblind constitution that requires the government to, at long last, put aside its citizens' skin color and focus on their individual achievements. Universities' recent experiences confirm the efficacy of a colorblind rule. To start, universities prohibited from engaging in racial discrimination by state law continue to enroll racially diverse classes by race-neutral means. For example, the University of California purportedly recently admitted its most diverse undergraduate class ever, despite California's ban on racial preferences. Similarly, the University of Michigan's 2021 incoming class was among the university's most racially and ethnically diverse classes, with 37% of first-year students identifying as persons of color. In fact, at least one set of studies suggests that, when we consider the higher education system as a whole, it is clear that the vast majority of schools would be as racially integrated, or more racially integrated, under a system of no preferences than under a system of large preferences. Race-neutral policies may thus achieve the same benefits of racial harmony and equality without any of the burdens and strife generated by affirmative action policies. In fact, meritocratic systems have long refuted bigoted misperceptions of what black students can accomplish. I have always viewed higher education's purpose as imparting knowledge and skills to students, rather than a communal, rubber stamp, credentialing process. And I continue to strongly believe, and have never doubted, that blacks can achieve in every avenue of American life without the meddling of university administrators. Meritocratic systems, with objective grading scales, are critical to that belief. Such scales have always been a great equalizer, offering a metric for achievement that bigotry could not alter. Racial preferences take away this benefit, eliminating the very metric by which those who have the most to prove can clearly demonstrate their accomplishments, both to themselves and to others. School successes, like students' grades, also provide objective proof of ability. Historically black colleges and universities, HBCUs, do not have a large amount of racial diversity, but they demonstrate a marked ability to improve the lives of their students. To this day, they have proved to be extremely effective in educating black students, particularly in STEM, where HBCUs represent 7 of the top 8 institutions that graduate the highest number of black undergraduate students who go on to earn science and engineering doctorates. HBCUs have produced 40% of all black engineers. And they account for 80% of black judges, 50% of black doctors, and 50% of black lawyers. In fact, Xavier University, an HBCU with only a small percentage of white students, has had better success at helping its low-income students move into the middle class than Harvard has. And each of the top 10 HBCUs have a success rate above the national average. Why, then, would this court need to allow other universities to racially discriminate? Not for the betterment of those black students, it would seem. The hard work of HBCUs and their students demonstrate that black schools can function as the center and symbol of black communities, and provide examples of independent black leadership, success, and achievement. And, because race-conscious college admissions are plainly not necessary to serve even the interests of blacks, there is no justification to compel such programs more broadly. ******. The great failure of this country was slavery and its progeny. And, the tragic failure of this court was its misinterpretation of the Reconstruction Amendments, as Justice Harlan predicted in Plessy. We should not repeat this mistake merely because we think, as our predecessors thought, that the present arrangements are superior to the Constitution. The court's opinion rightly makes clear that Grutter is, for all intents and purposes, overruled. And it sees the university's admissions policies for what they are, rudderless, race-based preferences designed to ensure a particular racial mix in their entering classes. Those policies fly in the face of our colorblind Constitution and our nation's equality ideal. In short, they are plainly, and boldly, unconstitutional. While I am painfully aware of the social and economic ravages which have befallen my race and all who suffer discrimination, I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution of the United States, that all men are created equal, are equal citizens, and must be treated equally before the law. Concurring opinion of Justice Gorsuch, joined by Justice Thomas. For many students, an acceptance letter from Harvard or the University of North Carolina is a ticket to a brighter future. Tens of thousands of applicants compete for a small number of coveted spots. For some time, both universities have decided which applicants to admit or reject based in part on race. Today, the court holds that the Equal Protection Clause of the 14th Amendment does not tolerate this practice. I write to emphasize that Title VI of the Civil Rights Act of 1964 does not either. Few pieces of federal legislation rank in significance with the Civil Rights Act of 1964. Title VI of that law contains terms as powerful as they are easy to understand. No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The message for these cases is unmistakable. Students for Fair Admissions, SFFA, brought claims against Harvard and UNC under Title VI. That law applies to both institutions, as they elect to receive millions of dollars of federal assistance annually. And the trial records reveal that both schools routinely discriminate on the basis of race when choosing new students, exactly what the law forbids. When a party seeks relief under a statute, our task is to apply the law's terms as a reasonable reader would have understood them at the time Congress enacted them. After all, only the words on the page constitute the law adopted by Congress and approved by the President. The key phrases in Title VI at issue here are subjected to discrimination and on the ground of. Begin with the first. To discriminate against a person meant in 1964 what it means today, to treat that individual worse than others who are similarly situated. The provision of Title VI before us, this court has also held, prohibits only intentional discrimination. From this, we can safely say that Title VI forbids a recipient of federal funds from intentionally treating one person worse than another similarly situated person on the ground of race, color, or national origin. What does the statute's second critical phrase, on the ground of, mean? Again, the answer is uncomplicated, it means, because of. Because of is a familiar phrase in the law, one we often apply in cases arising under the Civil Rights Act of 1964, and one that we usually understand to invoke the simple and traditional standard of but-for causation. The but-for causation standard is a sweeping 1-2. A defendant's actions need not be the primary or proximate cause of the plaintiff's injury to qualify. Nor may a defendant avoid liability just by citing some other factor that contributed to the plaintiff's loss. All that matters is that the plaintiff's injury would not have happened but for the defendant's conduct. Now put these pieces back together and a clear rule emerges. Title VI prohibits a recipient of federal funds from intentionally treating one person worse than another similarly situated person because of his race, color, or national origin. It does not matter if the recipient can point to some other factor that contributed to its decision to disfavor that individual. It does not matter if the recipient discriminates in order to advance some further benign intention or motivation. Nor does it matter if the recipient discriminates against an individual member of a protected class with the idea that doing so might favor the interests of that class as a whole or otherwise promote equality at the group level. Title VI prohibits a recipient of federal funds from intentionally treating any individual worse even in part because of his race, color, or national origin and without regard to any other reason or motive the recipient might assert. Without question, Congress in 1964 could have taken the law in various directions. But to safeguard the civil rights of all Americans, Congress chose a simple and profound rule. One holding that a recipient of federal funds may never discriminate based on race, color, or national origin, period. If this exposition of Title VI sounds familiar, it should. Just next door, in Title VII, Congress made it unlawful for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. Appreciating the breadth of this provision, just 3 years ago this court read its essentially identical terms the same way. This court has long recognized, too, that when Congress uses the same terms in the same statute, we should presume they have the same meaning. And that presumption surely makes sense here, for as Justice Stevens recognized years ago, both Title VI and Title VII codify a categorical rule of individual equality, without regard to race. Applying Title VI to the cases now before us, the result is plain. The parties debate certain details of Harvard's and UNC's admissions practices. But no one disputes that both universities operate programs or activities receiving federal financial assistance. No one questions that both institutions consult race when making their admissions decisions. And no one can doubt that both schools intentionally treat some applicants worse than others at least in part because of their race. Start with how Harvard and UNC use race. Like many colleges and universities, those schools invite interested students to complete the common application. As part of that process, the trial records show, applicants are prompted to tick one or more boxes to explain how you identify yourself. The available choices are American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, Hispanic or Latino, or white. Applicants can write in further details if they choose. Where do these boxes come from? Bureaucrats. A federal interagency commission devised this scheme of classifications in the 1970s to facilitate data collection. That commission acted without any input from anthropologists, sociologists, ethnologists, or other experts. Recognizing the limitations of their work, federal regulators cautioned that their classifications should not be interpreted as being scientific or anthropological in nature, nor should they be viewed as determinants of eligibility for participation in any federal program. Despite that warning, others eventually used this classification system for that very purpose, to sort out winners and losers in a process that, by the end of the century, would grant preferences in jobs and university admissions. These classifications rest on incoherent stereotypes. Take the Asian category. It sweeps into one pile East Asians, e.g. Indian, Pakistani, Bangladeshi, even though together they constitute about 60% of the world's population. This agglomeration of so many peoples paves over countless differences in language, culture, and historical experience. It does so even though few would suggest that all such persons share similar backgrounds and similar ideas and experiences. Consider, as well, the development of a separate category for Native Hawaiian or other Pacific Islander. It seems federal officials disaggregated these groups from the Asian category only in the 1990s and only in response to political lobbying. And even that category contains its curiosities. It appears, for example, that Filipino Americans remain classified as Asian rather than other Pacific Islander. The remaining classifications depend just as much on irrational stereotypes. The Hispanic category covers those whose ancestral language is Spanish, Basque, or Catalan, but it also covers individuals of Mayan, Mixtec, or Zapotec descent who do not speak any of those languages and whose ancestry does not trace to the Iberian Peninsula but bears deep ties to the Americas. The white category sweeps in anyone from Europe, Asia west of India, and North Africa. That includes those of Welsh, Norwegian, Greek, Italian, Moroccan, Lebanese, Turkish, or Iranian descent. It embraces an Iraqi or Ukrainian refugee as much as a member of the British royal family. Meanwhile, Black or African American covers everyone from a descendant of enslaved persons who grew up poor in the rural South, to a first-generation child of wealthy Nigerian immigrants, to a Black-identifying applicant with multiracial ancestry whose family lives in a typical American suburb. If anything, attempts to divide us all up into a handful of groups have become only more incoherent with time. American families have become increasingly multicultural, a fact that has led to unseemly disputes about whether someone is really a member of a certain racial or ethnic group. There are decisions denying Hispanic status to someone of Italian, Argentine descent, Marinelli Construction, Div 2D 294, 296-297S, 2D 1000, 1002, as well as someone with one Mexican grandparent, Major Concrete Construction. Yet there are also decisions granting Hispanic status to a Sephardic Jew whose ancestors fled Spain centuries ago, in re Rothschild, Lynn Legal and Finn Serves. SBA number 499, 1995 WL 5423982-4, and bestowing a sort of Hispanic status on a person with one Cuban grandparent, Bernstein, 94 calories, Rev., discussing in Re-Kist Corporation C, 2D 173, 193. Given all this, is it any surprise that members of certain groups sometimes try to conceal their race or ethnicity? Or that a cottage industry has sprung up to help college applicants do so? We are told, for example, that one effect of lumping so many people of so many disparate backgrounds into the Asian category is that many colleges consider Asians to be overrepresented in their admission pools. Paid advisors, in turn, tell high school students of Asian descent to downplay their heritage to maximize their odds of admission. We will make them appear less Asian when they apply, one promises. If you're given an option, don't attach a photograph to your application, another instructs. It is difficult to imagine those who receive this advice would find comfort in a bald, and mistaken, assurance that race-conscious admissions benefit the Asian American community, post. And it is hard not to wonder whether those left paying the steepest price are those least able to afford it, children of families with no chance of hiring the kind of consultants who know how to play this game. Just as there is no question Harvard and UNC consider race in their admissions processes, there is no question both schools intentionally treat some applicants worse than others because of their race. Both schools frequently choose to award a tip or a plus to applicants from certain racial groups but not others. These tips or pluses are just what they sound like, factors that might tip an applicant into an admitted class. And in a process where applicants compete for a limited pool of spots, a tip for one race necessarily works as a penalty against other races. As the trial court in the Harvard case put it, race-conscious admissions will always penalize to some extent the groups that are not being advantaged by the process. Consider how this plays out at Harvard. In a given year, the university's undergraduate program may receive 60,000 applications for roughly 1,600 spots. Admissions officers read each application and rate students across several categories: academic, extracurricular, athletic, school support, personal, and overall. Harvard says its admissions officers should not consider race or ethnicity when assigning the personal rating. But Harvard did not make this instruction explicit until after SFFA filed this suit. And, in any event, Harvard concedes that its admissions officers can and do take an applicant's race into account when assigning an overall rating. At that stage, the lower courts found, applicants of certain races may receive a tip in their favor. The next step in the process is committee review. Regional subcommittees may consider an applicant's race when deciding whether to recommend admission. So, too, may the full admissions committee. As the court explains, that latter committee discusses the relative breakdown of applicants by race. And, if at some point in the admissions process it appears that a group is notably underrepresented or has suffered a dramatic drop-off relative to the prior year, the committee may decide to give additional attention to applications from students within that group. The last step is lopping, where the admissions committee trims the list of prospective admits before settling on a final class. At this stage, again, the committee considers the characteristics of the admitted class, including its racial composition. Once more, too, the committee may consider each applicant's race in deciding whom to lop off. All told, the district court made a number of findings about Harvard's use of race-based tips. For example, the tips given for race impact who among the highly qualified students in the applicant pool will be selected for admission. At least 10% of Harvard's admitted class would most likely not be admitted in the absence of Harvard's race-conscious admissions process. Race-based tips are determinative in securing favorable decisions for a significant percentage of African American and Hispanic applicants, the primary beneficiaries of this system. There are clear losers too. White and Asian American applicants are unlikely to receive a meaningful race-based tip, and overall, the school's race-based practices result in fewer Asian American and white students being admitted. For these reasons and others still, the district court concluded that Harvard's admissions process is not facially neutral with respect to race. Things work similarly at UNC. In a typical year, about 44,000 applicants vie for 4,200 spots. SUP admissions officers read each application and rate prospective students along 8 dimensions: academic programming, academic performance, standardized tests, extracurriculars, special talents, essays, background, and personal. The district court found that UNC's admissions policies mandate that race is taken into consideration in this process as a plus factor. It is a plus that is sometimes awarded to underrepresented minority, or URM, candidates, a group UNC defines to include those students identifying themselves as African American or Black American Indian or Alaska Native or Hispanic, Latino, or Latina, but not Asian or white students. At UNC, the admissions officer's decisions to admit or deny are provisionally final. The decisions become truly final only after a committee approves or rejects them. That committee may consider an applicant's race too. In the end, the district court found that race plays a role, perhaps even a determinative role, in the decision to admit or deny some URM students. Nor is this an accident. As at Harvard, officials at UNC have made a deliberate decision to employ race-conscious admissions practices. While the district court's findings tell the full story, one can also get a glimpse from aggregate statistics. Consider the chart in the court's opinion collecting Harvard's data for the period 2009 to 2018. The racial composition of each incoming class remained steady over that time, remarkably so. The proportion of African Americans hovered between 10% and 12%, the proportion of Hispanics between 8% and 12%, and the proportion of Asian Americans between 17% and 20%. Might this merely reflect the demographics of the school's applicant pool? Perhaps, at least assuming the applicant pool looks much the same each year and the school rather mechanically admits applicants based on objective criteria. But the possibility that it instead betrays the school's persistent focus on numbers of this race and numbers of that race is entirely consistent with the findings recounted above. See, e.g., Sup. 3d, if at some point in the admissions process it appears that a group is notably underrepresented or has suffered a dramatic drop-off relative to the prior year, the committee may decide to give additional attention to applications from students within that group, cf. ante, opinion for the court. Throughout this litigation, the parties have spent less time contesting these facts than debating other matters. For example, the parties debate how much of a role race plays in admissions at Harvard and UNC. Both schools insist that they consider race as just one of many factors when making admissions decisions in their self-described, holistic, review of each applicant. SFFA responds with trial evidence showing that, whatever label the universities use to describe their processes, they intentionally consult race and, by design, their race-based tips and pluses benefit applicants of certain groups to the detriment of others. The parties also debate the reasons both schools consult race. SFFA observes that, in the 1920s, Harvard began moving away from test scores and toward placing greater emphasis on character, fitness, and other subjective criteria. Harvard made this move, SFFA asserts, because President Lawrence Lowell and other university leaders had become alarmed by the growing number of Jewish students who were testing in, and they sought some way to cap the number of Jewish students without stating frankly that they were directly excluding all Jews beyond a certain percentage. SFFA contends that Harvard's current holistic approach to admissions works similarly to disguise the school's efforts to assemble classes with a particular racial composition, and, in particular, to limit the number of Asian Americans it admits. Brief for Petitioner 12-14, 25-32. For its part, Harvard expresses regret for its past practices while denying that they resemble its current ones. Tr. of Oral Arg in number 20-1199. And both schools insist that their student bodies would lack sufficient diversity without race-conscious admissions. When it comes to defining and measuring diversity, the parties spar too. SFFA observes that the racial categories the universities employ in the name of diversity do not begin to reflect the differences that exist within each group. Instead, they lump together white and Asian students from privileged backgrounds with Jewish, Irish, Polish, or other white ethnic groups whose ancestors faced discrimination, and descendants of those Japanese American citizens interned during World War II. Even putting all that aside, SFFA stresses that neither Harvard nor UNC is willing to quantify how much racial and ethnic diversity they think sufficient. And, SFFA contends, the universities may not wish to do so because their stated goal implies a desire to admit some fixed number, or quota, of students from each racial group. Besides, SFFA asks, if it is diversity the schools are after, why do they exhibit so little interest in other, non-racial, markers of it? While Harvard professes interest in socioeconomic diversity, for example, SFFA points to trial testimony that there are 23 times as many rich kids on campus as poor kids. Even beyond all this, the parties debate the availability of alternatives. SFFA contends that both Harvard and UNC could obtain significant racial diversity without resorting to race-based admissions practices. Many other universities across the country, SFFA points out, have sought to do just that by reducing legacy preferences, increasing financial aid, and the like. As part of its affirmative case, SFFA also submitted evidence that Harvard could nearly replicate the current racial composition of its student body without resorting to race-based practices if it, 1. Provided socioeconomically disadvantaged applicants just half of the tip it gives recruited athletes and, 2. Eliminated tips for the children of donors, alumni, and faculty. Doing these two things would barely affect the academic credentials of each incoming class. And it would not require Harvard to end tips for recruited athletes, who as a group are much weaker academically than non-athletes. At trial, however, Harvard resisted this proposal. Its preferences for the children of donors, alumni, and faculty are no help to applicants who cannot boast of their parents' good fortune or trips to the alumni tent all their lives. While race-neutral on their face, too, these preferences undoubtedly benefit white and wealthy applicants the most. Still, Harvard stands by them. To be sure, the parties' debates raise some hard-to-answer questions. Just how many admissions decisions turn on race? And what really motivates the university's race-conscious admissions policies and their refusal to modify other preferential practices? Fortunately, Title VI does not require an answer to any of these questions. It does not ask how much a recipient of federal funds discriminates. It does not scrutinize a recipient's reasons or motives for discriminating. Instead, the law prohibits covered institutions from intentionally treating any individual worse even in part because of race. So yes, of course, the universities consider many non-racial factors in their admissions processes too. And perhaps they mean well when they favor certain candidates over others based on the color of their skin. But even if all that is true, their conduct violates Title VI just the same. The principal dissent contends that this understanding of Title VI is contrary to precedent. But the dissent does not dispute that everything said here about the meaning of Title VI tracks this court's precedent in Bostock interpreting materially identical language in Title VII. That raises two questions: do the dissenters think Bostock wrongly decided? Or do they read the same words in neighboring provisions of the same statute, enacted at the same time by the same Congress, to mean different things? Apparently, the federal government takes the latter view. The Solicitor General insists that there is ambiguity in the term discrimination in Title VI but no ambiguity in the term discriminate in Title VII. Respectfully, I do not see it. The words of the Civil Rights Act of 1964 are not like mood rings, they do not change their message from one moment to the next. Rather than engage with the statutory text or our precedent in Bostock, the principal dissent seeks to sow confusion about the facts. It insists that all applicants to Harvard and UNC are eligible to receive a race-based tip. But the question in these cases is not who could hypothetically receive a race-based tip. It is who actually receives one. And on that score the lower courts left no doubt. The district court in the Harvard case found that the school's admissions policy cannot be considered facially neutral from a Title VI perspective given that admissions officers provide race-based tips to African American and Hispanic applicants, while white and Asian American applicants are unlikely to receive a meaningful race-based tip. The district court in the UNC case found that admissions officers sometimes award race-based pluses to URM candidates, a category that excludes Asian American and white students. Nor could anyone doubt that these cases are about intentional discrimination just because Harvard in particular does not explicitly prioritize any particular racial group over any other. Forget for a moment the university's concessions about how they deliberately consult race when deciding whom to admit. Look past the lower court's findings recounted above about how the universities intentionally give tips to students of some races and not others. Put to the side telling evidence that came out in discovery. Ignore, too, our many precedents holding that it does not matter how a defendant labels its practices, that intentional discrimination between individuals is unlawful whether motivated by a wish to achieve class-wide equality or any other purpose, and that the absence of a malevolent motive does not convert a facially discriminatory policy into a neutral policy with a merely discriminatory effect. Consider just the dissents in these cases. From start to finish and over the course of nearly 100 pages, they defend the university's purposeful discrimination between applicants based on race. Neutrality, they insist, is not enough. The use of race, they stress, is critical. Plainly, Harvard and UNC choose to treat some students worse than others in part because of race. To suggest otherwise, or to cling to the fact that the schools do not always say the quiet part aloud, is to deny reality. So far, we have seen that Title VI prohibits a recipient of federal funds from discriminating against individuals even in part because of race. We have seen, too, that Harvard and UNC do just what the law forbids. One might wonder, then, why the parties have devoted years and fortunes litigating other matters, like how much the universities discriminate and why they do so. The answer lies in Bakke. Bakke concerned admissions to the medical school at the University of California, Davis. That school set aside a certain number of spots in each class for minority applicants. Alan Bakke argued that the school's policy violated Title VI and the Equal Protection Clause of the 14th Amendment. The court agreed with Mr. Bakke. In a fractured decision that yielded 6 opinions, a majority of the court held that the school's set-aside system went too far. At the same time, however, a different coalition of 5 justices ventured beyond the facts of the case to suggest that, in other circumstances not at issue, universities may sometimes permissibly use race in their admissions processes. As important as these conclusions were some of the interpretive moves made along the way. Justice Powell, writing only for himself, and Justice Brennan, writing for himself and 3 others, argued that Title VI is coterminous with the Equal Protection Clause. Put differently, they read Title VI to prohibit recipients of federal funds from doing whatever the Equal Protection Clause prohibits states from doing. Justice Powell and Justice Brennan then proceeded to evaluate racial preferences in higher education directly under the Equal Protection Clause. From there, however, their paths diverged. Justice Powell thought some racial preferences might be permissible but that the admissions program at issue violated the promise of equal protection. Justice Brennan would have given a wider berth to racial preferences and allowed the challenged program to proceed. Justice Stevens, also writing for himself and 3 others, took an altogether different approach. He began by noting the court's settled practice of avoiding the decision of a constitutional issue if a case can be fairly decided on a statutory ground. He then turned to the broad prohibition of Title VI, and summarized his views this way: the university excluded Bakke from participation in its program of medical education because of his race. The university also acknowledges that it was, and still is, receiving federal financial assistance. The plain language of the statute therefore requires finding a Title VI violation. Footnote omitted. In the years following Bakke, this court hewed to Justice Powell's and Justice Brennan's shared premise that Title VI and the Equal Protection Clause mean the same thing. Justice Stevens's statute-focused approach receded from view. As a result, for over 4 decades, every case about racial preferences in school admissions under Title VI has turned into a case about the meaning of the 14th Amendment. And what a confused body of constitutional law followed. For years, this court has said that the Equal Protection Clause requires any consideration of race to satisfy strict scrutiny, meaning it must be narrowly tailored to further compelling governmental interests. Outside the context of higher education, our precedents have identified only 2 interests that meet this demanding standard: remediating specific, identified instances of past discrimination that violated the Constitution or a statute, and avoiding imminent and serious risks to human safety in prisons. Within higher education, however, an entirely distinct set of rules emerged. Following Bakke, this court declared that judges may simply defer to a school's assertion that diversity is essential to its educational mission. Not all schools, though, elementary and secondary schools apparently do not qualify for this deference. Only colleges and universities, the court explained, occupy a special niche in our constitutional tradition. Yet even they, wielding their special niche authority, cannot simply assert an interest in diversity and discriminate as they please. Instead, They may consider race only as a plus factor for the purpose of attaining a critical mass of underrepresented minority students or a diverse student body. At the same time, the court cautioned, this practice must have a logical end point. And in the meantime, outright racial balancing and quota systems remain patently unconstitutional. Nor may a college or university ever provide mechanical, predetermined diversity bonuses. Only a tip or plus is constitutionally tolerable, and only for a limited time. If you cannot follow all these twists and turns, you are not alone. If the court's post-Bakke higher education precedents ever made sense, they are by now incoherent. Recognizing as much, the court today cuts through the kudzu. It ends university exceptionalism and returns this court to the traditional rule that the Equal Protection Clause forbids the use of race in distinguishing between persons unless strict scrutiny's demanding standards can be met. In that way, today's decision wakes the echoes of Justice John Marshall Harlan. The law regards man as man, and takes no account of his surroundings or of his color when his civil rights as guaranteed by the supreme law of the land are involved. If Bakke led to errors in interpreting the Equal Protection Clause, its first mistake was to take us there. These cases arise under Title VI, and that statute is more than a simple paraphrasing of the Equal Protection Clause. Title VI has independent force, with language and emphasis in addition to that found in the Constitution. That law deserves our respect, and its terms provide us with all the direction we need. Put the two provisions side by side. Title VI says, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The Equal Protection Clause reads, no state shall deny to any person within its jurisdiction the equal protection of the laws. That such differently worded provisions should mean the same thing is implausible on its face. Consider just some of the obvious differences. The Equal Protection Clause operates on states. It does not purport to regulate the conduct of private parties. By contrast, Title VI applies to recipients of federal funds, covering not just many state actors, but many private actors too. In this way, Title VI reaches entities and organizations that the Equal Protection Clause does not. In other respects, however, the relative scope of the two provisions is inverted. The Equal Protection Clause addresses all manner of distinctions between persons, and this court has held that it implies different degrees of judicial scrutiny for different kinds of classifications. So, for example, courts apply strict scrutiny for classifications based on race, color, and national origin, intermediate scrutiny for classifications based on sex, and rational basis review for classifications based on more prosaic grounds. By contrast, Title VI targets only certain classifications, those based on race, color, or national origin. And that law does not direct courts to subject these classifications to one degree of scrutiny or another. Instead, as we have seen, its rule is as uncomplicated as it is momentous. Under Title VI, it is always unlawful to discriminate among persons even in part because of race, color, or national origin. In truth, neither Justice Powell's nor Justice Brennan's opinion in Bakke focused on the text of Title VI. Instead, both leapt almost immediately to its voluminous legislative history, from which they proceeded to divine an implicit, congressional intent to link the statute with the Equal Protection Clause. Along the way, as Justice Stevens documented, both opinions did more than a little cherry-picking from the legislative record. Justice Brennan went so far as to declare that any claim that the use of racial criteria is barred by the plain language of the statute must fail in light of the remedial purpose of Title VI and its legislative history. And once liberated from the statute's firm rule against discrimination based on race, both opinions proceeded to devise their own and very different arrangements in the name of the Equal Protection Clause. The moves made in Bakke were not statutory interpretation. They were judicial improvisation. Under our Constitution, judges have never been entitled to disregard the plain terms of a valid congressional enactment based on surmise about unenacted legislative intentions. Instead, it has always been this court's duty to give effect, if possible, to to every clause and word of a statute, and of the Constitution itself. In this country, only the written word is the law, and all persons are entitled to its benefit. When judges disregard these principles and enforce rules, inspired only by extra-textual sources and their own imaginations, they usurp a lawmaking function, reserved for the people's representatives. Today, the court corrects course in its reading of the Equal Protection Clause. With that, courts should now also correct course in their treatment of Title VI. For years, they have read a solo opinion in Bakke like a statute while reading Title VI as a mere suggestion. A proper respect for the law demands the opposite. Title VI bears independent force beyond the Equal Protection Clause. Nothing in it grants special deference to university administrators. Nothing in it endorses racial discrimination to any degree or for any purpose. Title VI is more consequential than that. Asterisk. In the aftermath of the Civil War, Congress took vital steps toward realizing the promise of equality under the law. As important as those initial efforts were, much work remained to be done, and much remains today. But by any measure, the Civil Rights Act of 1964 stands as a landmark on this journey and one of the nation's great triumphs. We have no right to make a blank sheet of any of its provisions. And when we look to the clear and powerful command Congress set forth in that law, these cases all but resolve themselves. Under Title VI, it is never permissible to say yes to one person but to say no to another person even in part because of the color of his skin.